Let me out.
Why?
You started all this, yeah.
You screwing my chat, raising a bunch of shit.
I didn't say anything in your chat about anything. I never said a bad word about that standout.
Bullshit.
I never did. Don't tell me bullshit.
Bullshit.
We reached out to you twice, you lying bastard.
So how much of an asshole am I?
No, it wasn't that.
That's
You're
what it
lying.
was.
And you're lying again on everybody. You can
Really?
see you lying.
What's the problem?
Everyone is upset. Basically, I'm going to put it nicely.
Okay.
That you embellish a lot.
Okay.
I'm just,
Okay.
being
Yes.
a messenger.
No, I'll agree with that. I.
There you go.
I'm responding.
Go after a
I'm
woman.
responding to the question.
Don't go after
I'm
a
not.
woman.
I'm responding to
I'm
his question.
telling you.
I'm responding to his question. He asked me, and I'm telling him.
Get out of his
Well,
face.
I'm
Go
telling
ahead. Tell him.
I just did.
Tell him.
I'm not going.
Don't go after a
I'm
woman.
answering his
I
fucking
saw the
question.
video.
Did you see what she wrote? Go ahead.
And they've had enough.
Okay. Go.
Your ecosystem.
Whatever.
Where's all the money you made from your live stream?
What's
24
your
hours.
name?
Did you
Where's
send
your
it to
business?
Karen?
Where's your
Did you send it to Karen?
What
The
is it?
kids? How about the kids?
What have you done?
Put in your pocket. Like
Listen.
it. Hit the subscribe button on the way to.
You're trying to get rid of the movement.
It's on. I'll get another watch against you.
You're trying to destroy the movement, Dennis.
You're on what?
You know I'm
You
not.
asked Scotty.
I did. It's all on film. It's all on film. You said to Scott,
Put that fucking camera down and make it about John.
really? I had two people touch me.
All right, I think I'm here now. I have a new mic.
Yeah,
And
I can hear you.
for some reason it wasn't going, so I just went to the headset mic. This new mic is a good mic, and it'll sound much clearer and much louder. But we'll stick with this one for now. So that was interesting, Kate. All the friction yesterday. I think people are starting to realize that people like Tom CPU are just carpetbaggers coming in to generate content in order to make money and get attention. And they're outsiders. They don't give a shit about justice, about the town of Canton. They don't give a shit about Karen, really. It's all about themselves. And if they're starting to realize this about Tom CPU, that means, though they may not have the courage to go there yet, they know it's true about Turtle Boy too, because he is the ultimate carpetbagger. Tom CPU is just a cheap knockoff of Turtle Boy. He's a copycat.
Yeah, I mean,
Waking
Tom
up.
CPU is also intrinsically unlikable, and he's a creep. So it would make sense that after a while, people would get sick of him. And I watched the whole thing. I was like actually glued to this, and I usually don't watch him, but it was funny. Number one, because like he went in there knowing that these people were agitated with him and didn't really want him there, and he goes there anyway. Right. And then after they have the confrontation, Tom kind of retreats and goes, "Oh, I didn't do nothing." And then immediately comes back to antagonize them like clockwork. Right. Like, "Oh, I didn't do anything. Am I the asshole?" And then he goes back and, gets close to them within earshot and starts yelling, talking shit about them again, like clearly to antagonize him. His little buddy Boston Mike there was like salivating the whole time. Like, "Oh, you guys like this, right? Like, you like the drama." I mean, it was completely contrived. I thought it was hilarious when they had that weird looking girl, Esty, she showed up to mediate and she's screaming and crying like it's something serious. And my favorite part was at the end though, when this James White guy, Whitey, comes out, right? And Tom tries to talk to him and he's like, "I don't want to talk to you." So like the person that had to go to court that day doesn't even want you there, Tom. Why are you there? Why are you there? Just to cause problems, right? And that's gonna make people not like you.
Yeah, anything's an opportunity to do a show is really all it is. And I think, and people would say, "What about you, Kev? Aren't you doing the same thing?" Look, anytime I've made this clear before. Anytime the O'Keefe family doesn't want me doing what I'm doing, I'm happy to pull the plug. I am so sick of doing this. Believe me, you know that, this Kate. And
Yeah.
so, but the difference is we're trying to do it ethically, honestly, cover the truth. If I found out tomorrow that there was some crazy conspiracy and that Karen was innocent, I would report it. I'm not locked into something. I'm only following the evidence. Now the evidence is crystal clear on this to the point of ridiculousness. Like I don't know if you caught my show the other night, but someone had presented an article under an anonymous lawyer,
Yes,
and I read it. I
yeah,
read
I
it
read
out.
it. Yeah.
That was a really well written article, and and a lot of it is stuff that you and I have been saying for a long time too. But I just, when you look at it too, when it's well written like that, you're like, why don't other people get this? This is basic, obvious logic stuff. I don't understand. I don't understand that people smoking too much cannabis in this state. Is it the COVID virus?
Don't blame the pot. Don't blame the pot, Kevin. I resemble that remark. No way. I smoke pot, and I'm not that retarded. At least not with that. Oh, sorry, we're not supposed to use the R word. I'm not that stupid, but no, I think it is. It's a combination of sunk cost fallacy, I think, for a lot of these people at this point. They've put so much into this, and even as everything crumbles, I mean, again, I know that at first you were kind of drawn into the conspiracy. I don't really understand it, and I try to empathize with it, but it's just really hard for me personally to put myself in that headspace, because from the moment that I first read what they were saying about the supposed conspiracy, I really did think that Turtle Boy had jumped the shark, and that was the end of the blog. And because it was so ridiculous to me from the onset, right? So I don't really understand what drew people in at first.
Well,
I wish that I could understand.
227. That's what. Listen, now listen. We look at it now and say, at least for me, now maybe you understood this then, and also I think maybe you had the advantage of understanding what Turtle Boy was all about, which I didn't. But when I looked at 227, and I thought naively that data is just data, right? And the way that was presented in that first theory on April 12th by the defense was that this is just data that for some reason the state didn't find, but it's there. So I'm thinking if 227 happened, there's no innocent explanation for it. And I know maybe you've disagreed with me on
I
that too.
disagree with that, especially when you
No,
look at the totality.
nobody's
I will
making
say
that
this
sure.
though. I will say this though, where we differ too is, and a lot of people, I had the advantage of being able to access those court documents in their entirety, both sides, and read them.
Yeah.
Whereas it was being hidden from most of the public. And Massachusetts, it's a little bit, it's not impossible to get records, but it's not like Florida or Ohio or somewhere where you just put in an online form and get them very quickly, right? Like, there's a little bit of a process to it. I am fortunate enough that I have some resources to where I can get court documents quickly. So I understood very early on what she was actually being charged with and all the facts behind that. And I mean, even presuming that 227 was legitimate, and, at first I had no reason to believe that it wasn't. It just wasn't compelling evidence, when faced with the mountain of evidence against Karen Read. And I mean, I think that people do Google weird shit sometimes. Obviously, now we know that it wasn't Googled at 227 at all, but even when I was assuming that that was correct, there was so much compelling evidence against Karen Read that, I mean, none of this made any sense. And I think, again, that article, everything that article says, right, isn't hinged on or contingent on that 227 AM search. It's barely mentioned at all, if it is. I don't have it in front of me, but just the pure implausibility of this massive conspiracy and how lucky they got with Karen making those statements and Karen's taillight being broken and the taillight pieces being, on the scene and Michael Proctor being involved and all these things that, like, really it would be like a cosmic convergence for this to happen, to frame this woman. That's not really contingent on 227 or any other kind of, question or speculation that people throw out to try to muddy the waters. It doesn't really change the underlying facts. But again, I know that Turtle Boy was hiding, and Karen and everybody, they were hiding the actual court documents and just pulling out snippets to mislead the public. I do understand that part of it.
But just to explain where I was, and I think honestly my position was perfectly reasonable, and where most people would be, is that I looked at this and I said, and so I started a series on this called Framed with a question mark. So I was saying from the beginning that there are aspects of this that just don't make any sense. Who puts somebody out to die, or who put them out alive to die on their own lawn? At least if it's a weird thing to try to think you're going to create this idea that he was struck by a vehicle if he's actually been attacked by a dog and beat up. That seems really strange. But if you're going to do that, put him on the street. Why put him 7 feet onto your lawn? You're close enough to the neighbor's yard. Put them in your neighbor's yard. There was a lot of aspects of this case, but if data was just data, Maui's saying, Kevin, I turned the mic up. I don't know. I tested this new mic last night, and It worked great. If I can get back, if I can find out on the break how to get it working for some reason. And when I started the show this morning, I tested it and it was working. And then for some reason it wasn't. So this is why I got the mic, because this my other big mic, the Yeti mic, was having problems. And this headset mic for some reason is always lower and it has no volume on it. I have no way, there's no volume on this thing to turn it up. So I'll try to fix it.
I think I'm kind of loud, so I just turned my gain down on my mic.
Yeah, that
Yeah.
might help, because they can
Yeah.
turn theirs up, but it's not your fault, because I have the same problem when I go on court TV. I'm low when I use this. I'm lower than everybody else, so I'm trying to. So if the problem's on my end, we'll fix it out. But anyways, back to if there's no innocent explanation for just happen to making a search for how long to die in the cold when coincidentally your friend is doing that. So to me, that was a starting point there. And really I started questioning the theory much more seriously only when Adam Lally in court said, we have an independent expert who says that's not when the search was made. Now I'm like, okay, all bets are off here. Now we've got to go back to square one. But that was the main thing. There were other things in the case that were odd, or at least let me rephrase that. They seemed odd, which is very different, right? Once you hold on and get the explanation. So why didn't the people come out of the house? That seemed odd to me, I have to admit. And there were other aspects of it too. It's all presentation, but the way Chief Perkowitz was finding pieces, days later, I never bought into the idea of Colin Albert. I never bought into the idea of a 17-year-old kid attacking a 6'2" Boston cop because of some dispute over drinking beer cans on the lawn or something. I would never even talk about that on the channel, because to me that was always not only absurd but unfair to smear someone with that. But yeah, I think there was enough there with the 227 to at least say maybe something weird happened here.
I'm sorry, I'm looking at the chat. Everybody's saying, did you see the mugshot of Richard Green? Yeah, guys, I put it out because I pulled it. That's why you all have it, is because I put it on Twitter this morning. So I've seen it. I'm working on I have the full report, and I have his booking photo and all that. I'm actually working on getting some video of the incident. So hopefully I'll be able to get that. But yeah, I mean, Richard Green's a whole different thing. But you all have the mugshot because I put it out there.
Thank you, Kate. I'm going to pull it up right now so people can see it. And for all those people saying that they got it wrong, we'll see. Give me a second to share this.
There
all right,
he is.
Here he is. Richard Green. I mean, I got to admit, so when I first was looking at these files, it said he was 307 pounds. That's, even though he's a little chunky, that seemed very heavy. And I thought he was older than this. I thought he was probably like in his early 70s. So, but
no, I mean, I trust Ginny's research 110%. She's very careful. She does cross-reference. So I knew when she pulled it up, and I she's in my Discord server, so I was watching her work as she was doing it, and it was readily apparent that she had the right person. But then I noticed that on Twitter, all of the Free Karen Read people were like, you have the wrong Richard Green. So I went ahead and contacted the sheriff's office and was able to pretty quickly get the booking photos and, the full report of what happened. And again, I think that this is only really pertinent because it goes straight to his credibility, because the charges that he did get a diversion on, right? But part of that diversion was he was required to admit to the charges. So this is admitted and documented. He is a liar. He lied to police, and he was given multiple opportunities by the police to recant his story as it became clearer and clearer that it's not, he was not assaulted like he said. He was actually the aggressor that threw himself on the floor. And even when confronted with witness statements and video of the incident, Richard Green still chose to lie to the police anyway. So that's kind of a big deal, right? Because if you lie to the police, you'll probably lie under oath too.
Yeah. Just while you're talking, I'm trying to make sure. I never know what feed I'm going to tap into, because it seems like a lot of these channels are inconsistent. Well, sometimes I tap into Nesson, sometimes it's Court TV, sometimes it's Court TV's YouTube. It's for some reason and a lot of these people don't set up their feed until it starts. So you're not. There's always like there's more stress than there needs to be.
Yeah, I know. I think Lawn Crime is usually pretty good.
That's the one I used to tap into, and I actually also even bought the subscription to it. But there was some reason I had problems with that last time. But we'll look at that one too, because I think I couldn't remember my login is what it was. But let me try that one. But yeah, so why is it relevant? I think what we're going to say is that he's filed false reports. I think at one point I saw that he did a false 911 charge call, didn't he? I don't know if that was probably a different incident, but what went on?
No,
on
this
that
was the incident because he called 911. So it
Okay.
looks like they didn't end up charging him for that. They noted it in the report, but the actual charge was just the false report. But yeah, he's the one who called 911. And you know, essentially what happened was he was harassing the bartender. He grabbed her several times. He was yelling at her. Another patron comes in and says, "Hey, buddy, you know, let her go." That didn't really work. So then the bartender's husband comes in, kind of, you know, lightly places his hands on Richard's shoulders, and this is all on camera, so we know that is true, and says, like, you know, it's time to go. At which point Richard threw himself on the floor and then was asked to leave, and then, you know, called 911. Not the first time that he's been disorderly and drunk in public either. I find that to be not much of an issue, you know, whatever. Really, I think what's pertinent here is that he lied to the police. And obviously there's more issues with him. I'm editing up a video. I'm hoping to get it out today, but don't ever quote me on that because they're very intensive, where we kind of go through a little bit more of his history, because he's a grifter. He is a shady, unqualified, dishonest person he doesn't pay his taxes. Pretty much everything that they try to malign Chris Albert for, this guy is, you know, guilty times 10, right? Doesn't pay taxes, lots of failed businesses here. He's never actually worked for another company like doing any of this stuff. He's always kind of had his own, and they've been largely unsuccessful. I believe that he was probably selected because he's desperate and therefore willing to lie, you know, stretch details, look like an asshole.
Right. And we don't know for sure, but why would somebody like that call the police in an incident like that? And I can tell you from someone that was a bar owner, is with these, we don't know for sure what that was here, but usually they're looking for a lawsuit. You know, he's a slip and fall guy, basically.
Right.
I wouldn't be surprised if you see more of that in his background. Now, why is that relevant? If a guy is a slip and fall guy, if he's slipping Jimmy, you know, like from Better Call Saul, it's not surprising that he is going to get on the stand and say what it takes to get a payday. And that is relevant. I think Brennan might be able to bring that up. All right, good. So hopefully we'll stay on this feed here, and we should be good. Oh, is that? Let me see if Jen is here.
There's Gretchen Voss looking lovely as always today.
Oh, Gretchen's covering it today, huh? All right. Okay.
Good morning.
Great, these people have to travel. We're gonna want to see.
Oh, Jen is here too. Let me bring in Jen. Good morning, Jen.
Good morning. How is everyone?
We're doing very good. Good to see you. You're always you always feel much more awake and alert in the morning than I can possibly be.
You know why? Because I wake up. Well, this morning I woke up at 3:30, so I've been up for a while.
Oh my God! Wow.
Yeah, but you know, whatever. It's not a bad thing.
So we're supposed to have Drunken Turkeys on with us if he feels up to it at some point today. I think he just got out of the hospital yesterday. He was chatting with us from the hospital, my show a couple of nights ago. And he sent me a picture. I want to know the story of what happened to him, but he sent me a picture from the hospital of his arm. I couldn't even show it on the screen. It was too bad. Now, I was like, that is the worst. And I have looked at 1,000 dog bites because of this case in the last year and a half. And that is the worst dog bite I've ever seen. I mean, some kind of a dog it was a German Shepherd apparently, took a chunk out of his arm.
Oh.
A chunk out of his arm. It was just nasty.
Oh, that's terrible.
But I'm not sure if he's been on the channel with you before. I know he's a fan of your channel. He did mention
No,
that.
I have not. I've never spoken to him, so that'll be great. I hope he's doing okay. Dog bites, real dog bites, can really be tragic and painful, and Nasty.
Yeah. That it's like, now that's a dog bite.
I grew up with German Shepherds. I don't know if you knew that. I grew up on a farm, and even though I was not, my mother was amazing at raising shepherds, and one of my sisters also training and raising them. I was just around them. But we've always had shepherds. Still have shepherds at the farm.
Yeah, so that one.
Guys, can you hear me? I just switched to the mic. See if can you hear this at all?
Oh, it sounds amazing. Good job.
Oh, okay.
Good job, Kevin.
You know what it was, Kate? This mic it's a Shure mic, and it has a little mute feature on it that I must have accidentally touched.
That's it. Yeah. So my Yeti does too, and I like tend to use that rather than muting myself on StreamYard a lot. Yeah.
Yeah. This one is new. I just put it on last night, but the Yeti one, should be a good mic. It's been a good mic for a while, but for some reason it started getting buggy. And in fact, on Court TV this week, in the sound check beforehand, it was too buggy, so I had to go to this mic. But yeah, this mic is terrible, the headset one. But this mic here, the Shure mic, is pretty good.
You know, I bought a Shure mic, and it's terrible. I never use it. I have it sitting there often, but I never use it because I guess it sounds bad.
Well, let me, after the show, I'll tell you which mic I got, and if you think it sounds good during the course of the show today, you can invest in one. This is my first time using it, but it has a good reputation. There are different Shure mics, obviously. So we'll see. Jen, I wanted to ask you this too, because this goes to the heart of Rich Green and stuff like that. I think we've talked about this before, but when I was younger, I was on a jury, and one of the things that stuck in my mind, this was a civil case, and the defendant, the plaintiff brought in a doctor as an expert witness. Now, this guy was maybe 50. He wasn't elderly at all. The defendant was able to bring out on the stand that this guy had not practiced medicine for some reason for several years. But what he did do was testify nonstop in civil cases. And the implication being that he's a professional testifier. His word was for sale. Now, I know you've talked about in the past some of your experience of the defense teams reaching out to you. So talk a little bit more about that. I think people are interested in that.
Well, when it comes to expert witnesses, first of all, after people retire and if they go into the expert witness realm, obviously they're not working professionally per se anymore, and that's what they do. But they are relying on decades typically of experience with cases and with whatever their field of expertise was. And that doesn't just disappear because you're not practicing anymore. You still have all that experience you're drawing from. But I think more to your point is, are people for hire? Are people really for sale? And I can tell you that people who are true, qualified, responsible expert witnesses, they are not for sale other than what their true belief in a case is. For instance, I have a trial coming up, and unfortunately, after review of everything, I'm not going to be able to support the position that they had hoped. And I've let them know that. And I still may come on, spend more time in a consultation role, how to sort of mitigate what their client's looking at. But any true expert would never go against their thoughts. But that doesn't mean that that's the situation with all of them, because some are, like you said, they can be purchased for a price, unfortunately.
I mean, isn't this common in cases? I don't know if you agree with that, Kate, where it's just, from my experience in the few trials I've been involved in, I've been on as a juror a couple of times. It's just defense teams, and especially in a high profile case like this, they're always going to be able to find an expert to tell the story that they want told. And, it's a tacit understanding. It's not like somebody reaches out and says, yes, we want you to lie on the stand for us. No, they're shopping around to try to find someone that is going to give them an opinion. And now the people that are getting this packet of information, you've described it as getting in the past too, Jen, you know what they need to help them. And you look at that, and if you don't have integrity, you say, yeah, I can help you out with this. This is what I'm going to testify to. And that's how they find it, right? So
Well,
I don't know.
I don't know. I think most of the time it's kind of a gray area where you have experts that come in, and it's not so much that I'm going to lie or misinterpret or misrepresent. It's sort of like what Arca did, right? Arca had a very specific set of questions to answer, and that's what they answered, right?
Yeah.
It's not dishonest or unethical. It just doesn't really answer the germane question for the case, and it's done to kind of obfuscate, obviously, and confuse the issue and create some reasonable doubt, hopefully. What Richard Green is doing here is not the same thing. Like, this is purposeful doubling down on something that is clearly misinterpretation that has been corrected multiple times now by a myriad of experts way more qualified than he is, that are or were formally attached to the programs that he's using, right? This is a whole different ballgame. This is actually dishonest what this guy is doing.
Why is Bradel here? They just showed him on camera.
I don't, because he's a fucking weirdo. I don't know. Nothing better to do today, Probably gonna give Turtle Boy a handy in the bathroom or something.
I mean, is there any possible way where the defense is going to bring in something with him? For instance, Bradel's been involved with. We'll see. Are we going to hear anything today about the defense's motion to dismiss this based on misconduct?
They haven't even filed it.
Right. So I'm just trying to anticipate why they would want Bradel there, because he's got, involved with the conduct of Norfolk County, the charges in the Turtle Boy case, which connects these things in a way. So just wondering.
I don't think that the Karen's defense, I mean, I shouldn't say that because they've done some pretty outrageous things, but, connecting themselves further to Turtle Boy is probably not a good move.
Cell phone not at all.
Oh.
No cell phone. Thank you. I'll be with you.
We're getting the spinny thing. Sure, this is on the court's end, though, I believe.
Yeah.
To me.
Well, I'm looking forward to this hearing. Although I still don't understand, again, why the defense team would want to keep Green or would want to keep their dog bite expert. But nevertheless, we'll see what happens. I think really this is just the prosecution getting these individuals. And it's probably the defense.
This is what's going on. This very famous scene. You hear that story? The judge came out once had an 80 shooter and no car stood on the highway. Pants went right down to the ground. And the judge turned around and the court said, show's over.
So I had some good news. It's not fully official yet, but it looks like we are going to be able to publish the book before the next trial. So there's a lot of information in there. A lot of this information over the past year and a half, I owe to Kate's help too. But this is important information that I think that needs to be out in the public and before the trial. In theory, it shouldn't matter because the jurors should be people that are not influenced. But the reality is there's a huge, massive public feeling about this case, and most of that feeling is based on misinformation or packaging put out by the defense team. So what you really just want is a balanced playing field and objective jurors. Nobody on our side wants unfair jurors or jurors that have made up their minds. You want them to, maybe they've heard a little about the case, but they are going to go in and look at this objectively.
What's the name of your book, Kevin?
That is yet to be determined yet, but because you can't just pick this on yourself. The publishers have an input on it, and so there hasn't been a full agreement on it. But I think it might be something like Into the Storm, the Karen Read case. I wanted to go with A Perfect Storm of the Karen Read case, but they feel that's too close to The Perfect Storm. So
Right. Yeah, I know by the time that this comes out, unfortunately, so much stuff has been done that a lot of good titles have already been taken.
yeah.
Yeah. I mean, that's the thing is we know, and I, again, without speaking too specifically about anything, cause I can't, but we kind of know where the public discourse is going to end up here. So I think a lot of these grifters, Brother Council comes to mind, specifically the newest one, but that want to build their presence and make money off of this. It's very short-sighted. And they don't necessarily have the same information that we do, or not involved with the same things that we are, but it's foolish, right? Because again, like, objective people look at this and it's very hard to believe that this woman is factually innocent. Now, whether she's found guilty or not guilty in a court of law, still to be determined, but that's not, being found not guilty is not being found innocent. There seems to be some conflation with this, right? Like, as far as the actual facts go, is there a conspiracy? Is she a factually innocent woman being framed? Highly unlikely. And most people, I think, can see that.
Is Gretchen Voss there because they're going to discuss the in-camera review of her notes?
That's entirely possible, yes.
So just so people who may not be fully aware, Gretchen Voss had spent a lot of time interviewing Karen in the presence of her lawyers, had been to Karen's home, and a lot of there's audio that has been entered into discovery that is of her interviews, but the prosecution also this time wanted to go after her notes, and Gretchen has fought this for reasons of journalistic principle and also personal principle, because she had promised that she would not share them. So I really respect her stand on that. I don't know if you guys want to discuss that at all.
Well, I would say I think Gretchen is just a wonderful person. Having met her, I was very impressed with her, and I understand it's a tough thing to weigh. When you promise somebody that you'll keep everything quiet and not release it, it's tough for these journalists. I think she's a very ethical person, but there is an interest of justice and the homicide of a man in the balance. So, the bottom line is this should be up to the court, and that's who it's going to be up to. And I think she should have made it up to the court. I don't think she should have voluntarily given anything. And so I'm glad she's keeping with her journalistic principle.
So sitting in the back there is behind Paul O'Keefe's wife, Erin, is John Jackson. And this is someone who's became best friends with John O'Keefe on their first day of college. They met in line at the registration and instantly became friends and started commuting to school together, and just stayed like most people in John's life. He maintained a strong relationship with them, a bond for life. And John had told me recently that even as far as the last hearing, but in every hearing, as soon as Karen walks into court, she is staring down Paul O'Keefe, like in a hostile, aggressive way. And this is why I think look at the position that David Yannetti is. This is a common position. He is kind of shielding the O'Keefes from his client.
Well, he's really shielding his client from herself, but yeah, I get you.
Right.
Yeah.
Right.
I think even Turtle Boy, conceded that Karen's behavior in court is not helpful to her and is, inappropriate. Her facial expressions are really no excuse for it,
Right. And given that she's intelligent and she's an educated woman, the idea that anybody is going to be a genius in this case is not going to happen, but she's an intelligent woman. She's certainly intelligent enough to know that her behavior could be damaging, but yet she doesn't stop it. And I think what this really suggests is that she can't stop it. It's an impulse control thing. And she just, unless she's living in a complete delusion, and I think to some degree she is, but I don't think she can control this behavior. I think this is just kind of, there's a certain degree of, this is how her brain operates. It's the way she was born, and she can't control it. Does that seem unfair?
I think she's entitled. I think she thinks that she's portraying a position of strength when really she just looks like an asshole. I think that, she wants to look confident all the time. It's overcompensation, right? She wants everybody to know that I am so innocent that I'm angry about this, right? Which is, again, not always. You see people who have been falsely accused, and plenty of them are adamant about their innocence, but they behave with some sort of grace and empathy and understand. You know what I mean? Because they're genuinely innocent. That's not what we get with Karen Reed. So I think that part of it is that she probably believes that she looks strong and confident when in reality she looks cruel. And again, I think there is an impulse control problem, which I think contributed to what happened to John O'Keefe. Unfortunately, I think that she just isn't able to regulate her emotions very well. And I think, what comes through a lot of the time is this pervasive attitude of just entitlement from her.
Mm-hmm. Jen, I got a question for you. Is part of your FBI training, did you ever have any training in when you're interviewing suspects to look for body language or look for certain tells like that? Was that part of your work at all?
Oh, extensively. Yeah. I mean, that's what we trained with both when I went through just the academy. So I've been through the Federal Law Enforcement Training Center, which is in Glencoe, Georgia. FLETC is the acronym. And then also, of course, through Quantico. And then you do other training throughout your career. So in 28 years, I've been to the Reed School multiple times. And then, of course, Reed kind of was phased out a little bit, but multiple training on everything from eye movement to body language to voice inflection, fidgeting, shiftiness. And it's not a science, as you know, Kevin, but over the years, then you combine what you learn and train to understand with what you see people do that reinforces what you were just taught to look for. Yeah, it's a huge part of FBI training.
Do you see anything in Karen from your training?
Funny, when I was listening to you both, I muted myself. I do find you both quite, I love to listen to you because I get chuckles all the time, especially from Kate. But I think she doesn't care. I think it's just that simple. She doesn't care. She doesn't care what anyone thinks. And so for that reason, it doesn't matter to her what she does or says or what people think. She doesn't care. That's my view of her. I've seen people like this, and this is how they act.
Mm-hmm. Kate, do you have any idea how long today's hearing may be?
Well, it's not a Daubert hearing, so not as long as Murray Russell, hopefully. I don't know. I feel like Alessi has this weird, he seems to really prolong these things. I'm not sure why. I mean, hopefully it's not all day again. I mean, that just has to be so brutal on the family, right? These long all day hearings, not even trial yet, but
right.
I don't know. It's so hard to know what to expect with this defense team. Is part of it, right? And obviously they argue everything ad nauseum beyond the point where it should even be argued. It's pretty much, which is something again you kind of see in the Turtle Boy defense strategy too, right? Which is just, we're going to make the same tired arguments over and over and over again, annoy the judge, annoy the gallery, and then go outside and talk about how we won today. So I don't know. It's all performative. I think that's what annoys me the most about this case and the related cases. It's really no respect for the judicial system at all. It's just performative bullshit 24/7.
That was one of the in the article that I read the other day about this case by an anonymous Massachusetts attorney. He said something that's similar to what I've said in the past, but we both seem to think that really, despite what the public perception is, we think that the defense team really kind of blew it in the first time. They overplayed that by trying to grill witnesses who are not criminals, but are just actually ordinary people that got stuck in this case. They came across as, I think they risked annoying the jury and making them think that there was some kind of a shenanigan going on here with the defense team, and which helped the prosecution. So my contention was then, and it's this anonymous lawyer seemed to be saying something similar, was that the reason there was not a verdict had nothing to do with defense. It had to do with a weak case presentation by the prosecution, particularly where they didn't seem to understand the importance of explaining John's injuries in a better way, in a more convincing way, but also just inexplicably did not have one single expert witness that united the crucial correlation between the vehicle data and John's phone data that was presented by two different troopers. Trooper Paul did not know about John's phone data. Trooper Guarino did not know about the vehicle data. And it's that correlation that is really bulletproof in this case. And that wasn't presented. You also had Adam Lally in the opening statement say that John was struck at 12:35, and in the closing statement saying 12:30. So I really think the defense did not do a good job. They more celebrated themselves than trying to get the job done.
You were catching him, right? Larry Tippin? And Larry Tippin was walking back and forth.
No, and I agree. And I agree also with that, with the sentiment in that article that, you know, the defense has kind of boxed themselves into this ridiculous strategy because they're funding themselves through it now, right? So if you back down off the conspiracy theory, you risk upsetting the people that you've been bilking for every last red cent, which could hurt their ability to, you know, continue getting these funds, paying what she needs to pay. If she, in fact, actually owes her attorneys anything. I'm very skeptical about that. I think Karen lies about the money a lot. And there's absolutely no transparency in their fundraising whatsoever. So it's very hard to tell what's going where. But I would think that if you were in dire financial straits like that, and, you know, your goal was to just pay your legal fees, you probably wouldn't be going to fine dining establishments, you know, several nights a week and buying expensive clothes and, you know, being driven in expensive vehicles. I would think that's where you would kind of cut the fat first. But what do I know? I'm a poor person, so... Like, I just feel like you could downgrade to an Applebee's or stay home and cook. Like, if you were really in dire financial straits like this. So I don't really trust what she says about the money most of the time, if I'm being honest.
Jen, have you been involved with cases where there were retrials, where there was a hung jury and there was a second trial? Have you testified in any cases? What experience do you have with that?
So in terms of testifying, unfortunately, quite extensively, you know, it's kind of a joke that with the Bureau, typically the cases are so well put together and managed that everybody pleads. They plea and they usually proffer, and you find out a lot more about the case. I mean, oops, here we go.
All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court, Unified County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated. Judge, this is 22-117, the Commonwealth versus Karen Reed. Can I have counsel?
Good morning, Your Honor. Hank Brennan for...
Good morning, Mr. Jackson.
Good morning, Your Honor. Robert Alessi on behalf...
Good morning, Mr. Yannetti. Good morning, Ms. Reed. Oh. Good morning, Mr. Birchie. Okay, let's see. So we've got several matters for this morning that I want to discuss. So first, there's filed a motion to recover expert related expenses from the Commonwealth, and we'll discuss that in some manner at the end of the hearing today. We've also got Mr. Birch is here on Ms. Voss's opposition to the notes. And then there's the Commonwealth's motion for reciprocal discovery pertaining to the employees of ARCA. And the last one is the Commonwealth's motion to exclude witness Green's debunked opinions. So those are really in that order, except I think we should start with the non-party Gretchen Voss's motion to reconsider regarding the notes. And I do want to say that I received this morning a motion to file an amicus memo. The signatory is Mr. Albano. I've received that. I will allow that to be filed, and I've read the motion and the memorandum. So I will hear you, Mr. Birchie.
Good morning, Your Honor. Rob Birchie for Gretchen Voss. I'd like to start by just thanking the court for taking the time and giving me the opportunity to revisit the court's ruling of December 5. That ruling allowed in full the Commonwealth's renewed motion for all audio recordings, interview notes, emails, text messages, and voicemails in the possession of Gretchen Voss or MetroCorp. Ms. Voss and MetroCorp complied with the court's order for production of documents on January 2nd by producing to the court all of the responsive materials, the unredacted tapes, and the text messages that involved on-the-record communications by Voss with defendant Reed. I'm here today to implore the court to consider that part of its ruling, but also would require Gretchen Voss to turn over handwritten notes of an interview with Reed that the parties had agreed in advance would be off the record. What's in those notes is really a black box. The Commonwealth has provided no information indicating what it believes the notes will reveal, or why it has particular reason to delve into them. So the question before the court is whether the Commonwealth should be entitled to forage through this reporter's notes and compel her to break her promise of confidentiality with the source in the ungrounded hope of finding relevant and material evidence somewhere in those notes that will aid in a prosecution of the defendants. The stakes for Gretchen Voss are considerable, as she set out in her second affidavit submitted to the court with our motion for reconsideration. Her effectiveness as an investigative reporter depends upon her having the ability to use the tools of the journalism trade, and among them is the opportunity to rely and assure her sources that certain information they provide to the reporter will be off the record. The precedential stakes are high as well, because the Commonwealth is essentially asking the court to give no weight whatsoever to the off-the-record nature of the notes. And that is what renders a journalist's promise of confidentiality illusory. Off-the-record is a phrase you hear in virtually every conversation between a reporter and the source. Frequently, it's an interjection in the course of a sentence. This is off the record. A kind of lubricant that allows a source to have a free and full exchange with the reporter without having to guard every word they speak. And receiving information off the record is often a technique by a reporter to establish trust and rapport with the source. That source might be a whistleblower, might be a frightened migrant, or might, like Reed, be a criminal suspect. On page 2 of our motion for reconsideration, we quote from Primer on Journalism that says, off-the-record interviews, quote, are essential in building trust between journalists and their sources, allowing for candid discussions that can provide context or background without the risk of public disclosure. The result, it says, is to enhance the depth of the reporting and provide leads for other sources. In Ms. Voss's case, she states in her second affidavit, which we filed with motion for reconsideration, at paragraph 11, she says, obtaining information from sources off the record is a normal and critical part of my work. Like most investigative reporters, I frequently agree with sources, including named sources, to keep certain of the statements or interviews off the record, not to be published anywhere. Keeping my word on this is critical to maintaining credibility and trust, and thus maintain source relationships while not interfering with the flow of important information to the public. The court's December 5 order forces Gretchen to choose between either keeping her to her source and thereby violating the court's command, or else obeying the court's order and establish herself as a reporter who should not be trusted. It's an unnecessary choice to present to her, at least on the facts of this case. The court shouldn't insist on publication of the off-the-record notes because the Commonwealth has failed to meet its burden under Rule 17, so that mandated production of the records on the facts of this case would not be unreasonable or oppressive. And also because requiring Voss to turn over these confidential notes would damage First Amendment interests more than it would benefit the public in achieving justice for this criminal defendant. Now, I keep saying on these facts, because it's very clear that the inquiry is a fact-centered one. The First Circuit wrote in Bruno and Stillman that under Massachusetts law, the task is one that demands sensitivity, invites flexibility, and defies formula. While obviously the discretion of the trial judge has wide scope, it is a discretion informed by an awareness of First Amendment values and the precedential effect which decision in any one case would be likely to have. And in Re Cusimano in 1998, the First Circuit said, oh, that was a case like this one, where that involved a demand for financial information from an identified source. The same court reinforced the fact-specific nature of the inquiry. In Cusimano, they said, when a subpoena seeks divulgement of confidential information compiled by a journalist in anticipation of publication, courts must apply a balancing test. This test contemplates consideration of a myriad of factors, often uniquely drawn out from the factual circumstances of the particular case. Now, as I noted in the December 5 order, the court drew no distinction between the on-the-record and off-the-record interviews. When it applied the Massachusetts balancing test for mandating production of reporters' notes, texts, and audio texts, audio recordings, it did not treat this confidentiality promise as a factor in the equation. That, we submitted, was critical oversight, because whether you call it a privilege or not under Massachusetts law, Massachusetts does recognize that there is some degree of deference to be given to a promise of confidentiality. In Bruno and Stillman, the court said courts faced with enforcing requests for the discovery of materials, note it says materials, not source identities, and courts faced with enforcing requests for the discovery of materials used in the preparation of journalistic reports should be aware of the possibility that the unlimited or unthinking allowance of such requests will impinge upon First Amendment rights. In determining what, if any, limits should accordingly be placed upon the granting of such requests, courts must balance the potential harm to the free flow of information that might result against the asserted need for the requested information. So, what are the factors that the court should look at when conducting an analysis under Rule 17 and under the balance test? Taking Rule 17 first, set out in the LaRouche case, they cite the Nixon case where the Supreme Court ruled that in order to require production prior to trial, the moving party has to show, number one, that the documents are evidentiary and relevant, number two, that they're not otherwise procurable reasonably in advance of trial by the exercise of due diligence, number three, that the party cannot properly prepare for trial without such production and inspection in advance of trial, the failure to obtain such inspection may have done reasonably to delay the trial, and number four, that the application is made in good faith and, critically, is not intended as a general fishing expedition. In short, the court has explained that the special prosecutor in Nixon was required to clear three hurdles: relevancy, admissibility, and specificity. And the court held in Nixon that there was a sufficient likelihood that the tapes contained conversations relevant to the offenses charged, and sufficient preliminary showing that the subpoenaed tapes contained admissible evidence. In this case, however, there's been no showing that the handwritten notes contain information relevant to the offenses charged, and no showing that the handwritten notes contain admissible evidence. When you apply it to the facts of this case, there's uncertain relevancy of the information in the off-the-record notes. Not seeing them, it's hard to know whether they're relevant or not. There's no specificity whatsoever in the form of a preliminary showing by the Commonwealth that the notes contain admissible evidence. Compare that to the materials the court ordered disclosed. The court found that there were indications in the redacted audio tapes that when unredacted, the tapes would contain relevant and admissible evidence. That's on page 5 of the court's order, which says the Rule 17 standard is satisfied. not only based on its age. But there's no examination whatsoever of whether the interview notes would be anything more than a fishing expedition. To the contrary, the fact that nothing from that interview that resulted in the handwritten notes, nothing from that interview was used in the story. And that would suggest that the interview did not contain significant relevant information. As to the balancing test and the First Amendment interests, here too, the December 5 order ignores the on the record of the record distinction. That distinction matters. Confidential information is extra protection because, as stated in LaRouche, disclosure of such confidential material would clearly jeopardize the ability of journalists and the media to gather information and therefore would have an effect on speech. The group in LaRouche identified First Amendment interests that militate against disclosure of confidential information. One was the threat of judicial intrusion into the news gathering process. Another was the disadvantage of a journalist appearing to be a research tool for the government. Number three was the resulting disincentive to keep outtakes, or in our case, keep notes. And number four, the burden on journalists' time and records and resources in responding to subpoenas. And if you look, Your Honor, at the affidavit of Chris Vogel that was submitted with our original opposition, he talks about each of those factors in his affidavit from paragraphs 13 through 18. He says he worries that compelled disclosure may lead to a public perception that Mrs. Voss is taking sides in this case or is acting as an investigative arm for the judiciary. Trust in the news media is already fragile because reporters compile information for a living. They will always be attractive targets of discovery for one side or the other. The unrestrained use of subpoenas to compel testimony or documents from reporters will create or reinforce the impression that objective journalists are working as agents of the government or the defense. The Fourth Estate can only serve its role as a pillar of democracy if it has the public's trust. Second concern that editor Chris Vogel pointed out in his affidavit is that another risk of compelled disclosure is that if it becomes easy or routine to subpoena journalists to hand over their interview notes, the legal and administrative costs of battling, complying will chip away at the precarious resources of much of the media. A third factor that was concerning him was that easy allowance of media subpoenas also risks leading to a decline in investigative journalism altogether. This is the most expensive kind of journalism. Reporting, writing, editing, and fact-checking investigative pieces take significant time and resources. Magazines like Boston Magazine will not be able to risk becoming enmeshed in situations such as this one, with the result that they shy away from controversial topics and the flow of vigorous reporting will suffer. We'll feel we have no choice but to select tamer, less controversial topics for our coverage. Another concern expressed by Editor Vogel is that reporters will be incentivized to destroy notes and interview tapes after a story is published, and that could harm the news outlet that it later needs to follow up on that piece. A fifth consequence is that reporters may tend to be circumspect in the way they gather information, in the way they conduct their interviews, and not be so vigorous in their questioning of sources and documenting of interview notes, aware as they will be that the work may become the public and judicial oversight. And finally, one factor that separates this case from many other cases out there is that Gretchen Voss has been the subject of invasive vitriol simply for writing about this controversial and very public matter. Public disclosure of her interview notes in this case risks putting her again in the limelight. Now, the court mentioned in its ruling that it appeared that she was no longer in fear of harassment because she had attended every day of the trial. I would submit that that shows that she was dedicated to covering the trial, come what may. She has, she tells me she has in the recent past gotten more pushback on social media, including the fact that one commenter on Facebook, who I won't name, posted her personal telephone number for everyone. And the commenter to that post suggested I'll call her right away. And she's received several phone calls since that time. Because of the disproportionate harm to First Amendment and Article 16 interests caused by production of the confidential interview notes, we ask this court to consider its December 5 ruling and deny that part of the Commonwealth's motion that seeks those notes.
All right. Thank you very much.
Thank you, Your Honor.
I do have one point to make to you, Mr. Birch. In the amicus brief or the memo that was filed this morning, I just want to be clear that I am not looking for Ms. Voss's own interpretations as well as her likely impressions and thoughts about the interview and overall story to be provided. But it makes sense to me, and I'm going to hear from the Commonwealth, and if you want to respond first, that any information that reflects or relates to conversations with the defendant must be turned over.
I'm not sure what the question is.
So I'm not looking, the amicus brief and your argument suggests that if I order these notes to be provided, and just to be clear, I do appreciate that they were provided to me to review in camera. So I can see a distinction between what I'm being told that generally all notes reflect the author's interpretations as well as her likely impressions and thoughts about the interview and overall story. That's not what I'm considering releasing. But I think in this criminal case, the Commonwealth has proven that any material that reflects or relates to communication with the defendant must be turned over. So what I'm going to propose is that I do believe that there's some material in these notes that I don't need to provide to the Commonwealth, that I don't need to order be provided to the Commonwealth, that are just sort of observations. It's the communication between the defendant that's critical here. So I'm going to give you the opportunity to propose redactions to me. I have the notes, and you can propose redactions to things that are not reflective of communication with the defendant, observations, things of that nature.
Well, Ronna, there's nothing in the interview notes that is reflected in the story except architectural details, that there was a rosary on the bureau and the wall was blue or whatever it might be. And I went through the notes with this question in mind. Can you separate the impressions, integrity of the thoughts of the writer from the statements of the interviewee? And I don't think they're distinguishable. I think they're all melded together in one. And frankly, it's her selection of questions that she asks Ms. Reed that gives an eye hole into what her thoughts are about the case. You shouldn't have to produce that work product. And the Commonwealth hasn't shown that there's any more relevancy to these conversations with Gretchen Voss than there would be with any other conversation that Ms. Reed had with anyone else. There's no reason for the Commonwealth to be going after Gretchen Voss as a report for this, other than the fact that she's a reporter and she's done the investigative work already, that presumably the Commonwealth has already done.
Okay,
Thank you.
thank you. Commonwealth?
Your Honor, I'll simply say we defer to the court's judgment and whatever limitations the court imposes. I have no further argument.
Okay. All right, so I'll take this under advisement. Thank you. All right, so paper 442. This is the Commonwealth's motion for reciprocal discovery pertaining to employees of ACA. And I know from when we were last in court, the Commonwealth was perhaps having conversations with the federal people to see if you could get anywhere with this. Is there anything I need to know in that regard? And if we need to do it at sidebar, we can do it at sidebar.
I don't think there's a need, Your Honor.
Okay.
Although it's not incumbent on the Commonwealth to pursue Rule 14 discovery of a party that's going to proffer an expert, Commonwealth made best efforts anyways. I filed a TUI letter, and I was unexpectedly not disappointed when I received a response last night. It's insufficient, it's inadequate. So the issue of pursuing Rule 14 discovery through the proponent of the expert, that being the defense in this case, is something that is a matter we're going to have to address.
Okay.
I did speak to the defense this morning. Since the TUI letter came last night, they have, I don't want to speak for them, but have asked if we would consider some time so they can respond. I am content if it gets deferred until the next date, but it is an argument that needs to be made.
Okay, who's arguing now for the defendant?
Good morning, Your Honor.
Morning.
I agree with Mr. Brennan's recitation of our conversation this morning. If it pleases the court, we did get that TUI letter. I was copied in on that letter late last night. Reviewed it last night. I think that it'll be incumbent for me to at least analyze that letter in a little bit more detail and utilize that letter in my response to the Rule 14 argument. So if we could have another date.
Sure, well, we have next week, Thursday and Friday scheduled.
That's what I was thinking.
So we'll do this next week and come up with proposals on how we can certainly not violate anything that the federal court has said we can't do, but ways that we can go about it.
We'll be mindful.
All right, so if you can work on that, I'd appreciate that.
Sure.
So I will take the lead from the two of you on that.
Thank you.
Okay. All right, so this brings us to the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions. So I have received a great deal of pleadings on this. So the Commonwealth's motion, and there was a affidavit attached, a report attached from Mr. Whiffen. The defense has filed an opposition, an affidavit from Mr. Green, and then another affidavit from Mr. Green that doesn't, they're two separate affidavits. And the affidavits are clearly different in substance. So I'm a little, I don't know what you want me to think about that, but why don't we hear the Commonwealth on its motion first?
May it please the court, we filed a motion to exclude Mr. Green as a witness regarding 2 points. The first is a claim that a witness's phone made a search for a phrase to the effect of "how long to die in a cold" at 2:27 a.m. And secondly, to exclude an opinion that there was some type of intentional deletion of that entry. This case, I propose on behalf of the Commonwealth, is appropriate for a Lanigan hearing. At that Lanigan hearing, I suggest that Mr. Green should testify, answer questions about his affidavit and opinions that he would like to subject the jury to. In fairness, the government would call an expert as well. If this case, as the court proposed, potentially scheduled for next week, Mr. Whiffen would not be available, but Ms. Hyde would be available, and I would call her as a witness. Mr. Whiffen, if necessary, is available later in the month as a witness. My suggestion is there should be 2 witnesses, Mr. Green and 1 witness from the Commonwealth. The Commonwealth witness will be able to explain the science, the data, forensic science, and methodology. And Mr. Green, I suspect, should be in a position to explain his ultimate opinion, because what we see in his affidavit is absence of methodology. Mr. Green has filed 2 affidavits in this case. They are very similar, but there are very significant changes to those affidavits. And it stands out as very interesting, the changes to the affidavits, when I look at them. On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now that is odd, because usually a professional knows what they do for a profession. Simple explanation of what he does stands out. Also stands out when using technical terms. They either were wrong or changed from the first affidavit to the second affidavit. For example, number 9, he talks about the download as a full file system extraction, then changed to an Apple iOS full file system. My point is that when you look, this isn't simply misspellings or poor grammar. There are terms of art that are wrong between the affidavits or changed. When you're using the terminology of an item that is a forensic tool, such as gray key, it is spelled wrong throughout the affidavit. And so it seems to me that Mr. Green's affidavit had some assistance in building it. And the tone of the affidavit supports that thought. When we look at Mr. Green's affidavit, it is not that of a forensic examiner, it's that of an advocate for the defense. When we look at his affidavit, there is quite a bit of advocacy, insinuations and surmise and conjecture and claims that have no factual basis, but there is little on methodology. In ways, it is a very dangerous affidavit to simply make assaultive comments that a user did something, purposely deleted a very important phrase, how long to die in the cold, without any forensic data or evaluation or validation. Similarly, when we look at his affidavit, it is replete with accusations suggesting, never proving, never providing fact, that there was some type of manipulation or tampering with evidence. Now, this is not the role of a forensic examiner unless there is proof, in fact, that happened. But when we look through his entire affidavit, we don't see any attachment of raw data. We don't see an updated report. We don't see any viable information that in any way supports his speculative accusations. And so the defense, without having an opportunity for Mr. Green prior to trial, stand behind these statements under oath, would like him simply to come before the jury, make these salacious comments, and then leave it to the government to knock it down. And that might be a common viewing the transcripts of this case, but the Commonwealth does not intend to simply let evidence come in that's not qualified, that's not factually sound, and then go knock down glass houses. That is not the approach the government's going to take to this case. Mr. Green's going to testify. He should have a report that is factually based with methodology supporting these claims, these narratives that he's proposing. Considering testing in this case, there are certain tools that are used. The defense wants to propose that there's some type of race that Mr. Green looked at or used more tools than a Commonwealth expert. The tool is simply software. A good analogy is that of an X-ray. Anybody can take an X-ray, but it takes an expert then to interpret the X-ray, to interpret the data. In this case, Mr. Green, in his affidavit, proposes that because he used a number of tools, because he has a number of X-rays, that somehow there's significance to it. But what it lacks is a forensic analysis of that information. And it is clear in his affidavit that it lacks that. He cites two opinions. His first opinion is based on Cellbrite processing and Axiom processing. I'm not going to go through all the little details that we dispute or go through a technical assault on each point, although that the overall idea of this evidence is why this should be subject to a Lanigan hearing and why we are willing to call our own expert as well, so that the record is clear and the science and data is clear. Instead of doing validation or testing, relying on Cellbrite, what Mr. Green has done in section number 13 of his affidavit is stepped aside from methodology, and instead he cites that he called Cellbrite technical service. Now, this is the forensic examiner who is supposed to go through the process, and yet he defers it to technical support of Cellbrite. Technical support in Cellbrite, he relies on to say that this artifact where this search is stored is appropriate. And he remains standing on that foundation as why somehow there's some validation that this search occurred at 227. But then when he learns that Cellbrite, after actually doing analysis and study and updates and engage in methodology and review, determined that the way that was assessed is unreliable and the program has been updated, which no longer shows the 227 search at 227, and I'll explain why for good reason. I'm sure the court has heard this before. Mr. Green then denounces the very source that he relies on. And so on one hand, he's saying, I relied on technical assistance of Cellbrite, but then when they told me what I didn't like, I can ignore that part. He then defers to Axiom. Axiom, the government, the defense house, is a separate source that reinforces the same point when clearly it doesn't. You can see in number 14 of Mr. Green's affidavit, he talks about the fact he uses these different programs because he wants to view data. And that gets back to the X-ray analogy. He is viewing data from many different programs that say the same thing, but he never goes on to analyze it. What is troublesome about his affidavit in section 14 is he attempts to use resource material to convince this court that rather than methodology, these summary statements are something that the court should rely on. And so what he does is he takes an excerpt, page 7 of his affidavit, number 14, and he says that the Axiom user manual describing the artifact as follows, that the artifact is in Safari suspended state tabs, and then it has the last interaction date time, and the date and time of the current tab state when it was last interacted with on the local device. And so he's taking a piece of the manual, they don't introduce the manual, and he tries to use that to buttress that this search happened at 227. What you're not offered is that in the Axiom notes, in their artifact reference guide for the description of Safari suspended state tabs, which he's referring to, and this is the death knell really for the analogy that the defense tries to make. The Safari suspended tabs contains the current state each browser tab in Safari that is currently open on the local device. The date and time are only updated when the user interacts with that tab on the local device. Since these are local tab states, results from the artifact may contain an earlier date and time compared to the results in the Safari history artifact if multiple devices on one iCloud account. And so by Axiom itself, it makes clear that an artifact in a tab can reflect a time that is much earlier than the actual search. And this has been presented to the court, and we've provided the trial transcripts of Ms. Hyde and Mr. Whiffen. When a tab is open, many tabs can be open. It is open at a particular time. And if that tab is reused, the original time will imprint. And so certainly Mr. Green knows of the Commonwealth's argument. He knows of the opinions by Mr. Whiffen and Ms. Hyde because he takes shots at them or makes mention of them in his report. And yet he does nothing as far as validation to consider the arguments and dispel them. He does nothing in his affidavit to address the methodology. Quite to the contrary, when you see Mr. Whiffen and Ms. Hyde's reports, it isn't baseless opinions and advocacy of a side. When you look at their reports, it is replete with methodology, fact-based, information-based, the study of the particular device at hand. The contrast between the actual use of methodology that is reflected in Ms. Hyde and Mr. Whiffen's report and this affidavit is so clear. Now, there are two opinions that are proposed to this affidavit. The first is the claim that How Long to Die in the Cold was somehow inputted at 2:27. The only effort that appears in this affidavit by Mr. Green is in section 15, where he did a low-level analysis of the wall file. Now, I am not an expert, and that's why the court should hear from Ms. Hyde or Mr. Whiffen and Mr. Green. But a simple understanding, wall file can contain information as a repository. And the description or misunderstanding by Mr. Green of the wall file is clear in his affidavit. In fact, he implies that there were 3 searches in his affidavit, number 16. Let's look at this phone that there were 2. Surprised that his second opinion is an attempt really just to create confusion, to disparage, and to make claims that are factually untrue. It's necessary to have this claim because number 1 doesn't have any resonance. Anything somewhere, somehow. Not an uncommon. The claim or the opinion number 2 the defense would like the jury to hear is that somebody somehow, whether it was a person, presumably the witness in this case, or the police somehow manipulated the phone. I dare say there's no evidence to support that. And yet, in an affidavit under oath to the court, in an attempt of advocacy, this witness is comfortable and willing to promote a claim that has no factual basis. If a witness, an expert, is going to promote in an affidavit a claim with no factual basis, we should not trust without letting that have any merit or value. In opinion number 2, this expert, so-called expert, takes the liberty to say that the McCabe cell phone could have been manipulated. Not that it was, not that I did a study, not that I have a fact. It could have been manipulated, then rehashed after manipulation with the PDF being modified. Wow. An extraordinary conspiracy in the world of forensic science to be able to accomplish all of those tasks. So if he has no basis in fact or methodology, no good faith basis to make this assertion, why is he? Why is he? It is because the claims he makes in opinion number 1 are so scientifically and forensically unsound. This is a tactic to confuse the issue. And think about the import of this baseless claim by Mr. Green. It is suggesting that a witness with no other evidence whatsoever was involved in a conspiracy to murder somebody. That's the implication that he wants the jury to be confused by. Otherwise, there'd be no other reason to make the suggestion. That is an extraordinarily harsh claim when you don't have any facts. Now, how could one cause manipulation? There is scientific ways that could be explained how manipulation could occur, but we don't see any of that in this affidavit because it didn't exist in this case, because there was no deletion or manipulation by the witness. There was no manipulation by the police who processed this phone. If there was, there would be some proof. This affidavit speaks volumes by the absence of fact in data and science. Mr. Green does nothing to try to demonstrate that there was user deletion on this phone or that there was manipulation by the police. When you look at the data in the phone, the question arises, why is there a 624 search and not a 623 search? The phone stores the last entry into the tab. It's not just science, it's common sense. Common sense that Mr. Green ignores. And so not being able to prove user manipulation because it happened, he turns to police manipulation. And he says that there can be a problem where the hashes don't match, but the problem is the hashes do, they match. He complains that he did not receive the PDF when he received the download. And because there was a production at different times, he then sprints out into a different universe and suggests that somehow it must be because there's manipulation. And again, doesn't prove it. There's actually ways that a real forensic examiner can look at the PDF, the gray key file, and the phone and determine whether manipulation occurred. There's a program called XMP and another one called Magic. The problem was expert witnesses went through that process. No manipulation. But Mr. Green doesn't even go through the process to disprove his own theories. If he used methodology, he could simply dispel his own claims. It's either he doesn't understand the forensic technology to do that, or he chooses not to do it so he can just posit hand grenades throughout the case and let them resonate wherever they fall. In an attempt to create some doubt or uncertainty or merit some conspiracy, he lists a number of what he calls anomalies, which are really not anomalies at all. I could go through each one of them. I could give a difference of opinion. I could show that Mr. Green's anomalies have no basis in fact, but suffice to say, I think this should be done by qualified experts, and that's why there should be a Lanigan hearing. There is such misunderstanding of forensic science in Mr. Green's claims and anomalies. If he's going to make these assertions before it goes before a jury, he should sit in the witness seat under oath, as the Commonwealth witnesses should as well, and he should justify, explain to the court why he did not engage in methodology and how he has come to these extraordinarily baseless, inaccurate, and prejudicial claims. The Commonwealth has to, the court rather, has to look at Lanigan and whether or not a hearing is appropriate in this case. When we look at the different non-binding factors of Lanigan, we look at number one, whether it has been generally accepted in the scientific community. The software has been generally accepted in the scientific community. So hasn't the effort of a forensic examiner, the expertise. And the defense complains in their motion, the Commonwealth has not properly addressed the methodology of Mr. Green. Well, the reason why is Mr. Green does not provide any methodology. So this is the way to address the methodology. Number two, the opinions have been or can be subjected to testing. Well, we see Ms. Hyde and Mr. Whiffin's report directly contradict the assertions, the unsupported assertions of Mr. Green. There is no testing that his opinions have been subjected to. There is no peer review. There is no other alternative support for his opinions. They're just broad, baseless claims. Number three, has been subjected to peer review and publication. Certainly the science, the forensic science has, the software has, but the interpretation and Mr. Green's interpretations, it hasn't been subjected to anything. In fact, it changes. Has an unacceptably high known or potential rate of error. Well, if we see and read Ms. Hyde and it's just a high level of error. It's gross error. It's total error. It's wrong. And is governed by recognized standards. Well, if you look at the history report that the defense filed as an attachment, it talks about a forensic examiner's obligations to verify, to test things that Mr. Green didn't do. Their own report that they offer in support undermines the idea that Mr. Green did anything to validate or support his opinion. And as we see from both Selbright, he does not follow the protocol. He does not follow Axiom or the guidance that they give him. He sidesteps both of them to give the opinion he wanted to advocate for the defense. At every turn, positions of Mr. Green are not only unsupported, they're unverified. And so what arises from this subterfuge is that Mr. Green is really just a vessel or an attempted vessel for the defense, third-party culprit defense. It is not lost on me, I'm not unmindful of the data on the phone being a search how on Diana Cole that occurred after 6 a.m. in that morning coincides with first responders' testimony that the defendant herself was asking these very same questions around that time about Mr. O'Keefe and how long he could survive Nicole. Under the extraordinary broadness of circumstances and the depth of the amount of witnesses and information in this case, it is hard to think that that just happened by happenstance, that there is a inquiry, something forming in the mind of the accused is then shared with the witness, Ms. McCabe, and in response, she makes the search, which is entirely supported by all the credible forensic evidence. If Mr. Green is going to be a witness in front of the jury in light of the fact that he has no methodology and he's wrong on the science, in addition to the fact that he wants to now appear as advocate for the defense and accuse everybody and anybody without articulating who, just anybody other than the defense, he should have to stand behind those claims under oath. And so I'm asking for a landing and hearing. We are not shying from our burden. We're more than happy to bring in a witness so the court can contrast the two. Thank you.
All right, thank you. Mr. Leslie?
May it please the court. Mr. Green is eminently qualified to provide testimony in this case with regard to the subject matter that has been challenged by the prosecution in this case, and that is with regards to the search house long to die in the cold that occurred at 2:27:40 a.m. on January 29th, 2022. Mr. Green, and I want to cover the baseline for this hearing first. Mr. Green testified at the first trial. He testified without objections as to his qualifications. He testified without objections to his methodology. Your Honor sat, obviously presided over that trial. Your Honor did not issue after his testimony any limiting or curative instructions with regard to either his qualifications or methodology, nor did the prosecution after his testimony stand up and ask for any such limitations or qualification. The baseline for his qualifications and methodology was established again without objection.
But they are being challenged now.
I was just waiting, Your Honor. They are being challenged now, but the reason I state that is because what Mr. Green has provided in response to this motion is even more detail than what happened in the first trial. In Mr. Brennan's argument, he did not make one argument about Mr. Green's qualifications. Zero. So I'm assuming, because there's nothing in their motion that even goes into why he might not be qualified. So to me, Your Honor, that's a tacit concession, if not expressed, that he's qualified. And of course, he has to be qualified in digital forensics because there are 5 other areas of digital forensics opinions and methodology that Mr. Green is testifying about that has not been challenged. So to me, it is rather odd right off the jump that there's no challenge to 5 other areas of data forensics, and there's just this challenge to one aspect of his whole testimony and opinions. I have provided Your Honor with 2 exhibits demonstrative in support of my oral argument. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, and Exhibit 2 is entitled Digital Forensic Product Tools Used by Witnesses. The Commonwealth has agreed to my use of those exhibits. They had some, I agreed to theirs. And I would like to, Your Honor, use those in a moment. The Commonwealth, in its oral argument, said 10 times just now that there's no methodology and that Mr. Green does not articulate a methodology. That is incredible to me because the opposition and Mr. Green's affidavit, in fact, are replete with the methodology. And here is the key, Your Honor. While Mr. Brennan challenges the methodology, none of his witnesses, neither Mr. Whiffen nor Ms. Hyde, challenge the methodology. As a matter of fact, in their 2 reports, neither of them even describe Mr. Green's methodology, nor do they challenge it. And of course they can't, because it's the same exact methodology that they use. And that's what I would like to go to now. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, J. McCabe iPhone Data. And I prepared this. This is just what's in our opposition. It's in Mr. Green's affidavit, but it summarizes what the methodology is that we're talking about here. What is that methodology? Step 1, you receive, and this is to answer the question about what is the proper interpretation of the artifact in question that everybody agrees is the artifact. Step 1, receive a full file system image of extracted data from the Commonwealth. For example, the defense received it on a USB thumb drive. That's undisputed. If you look at the reports of Ms. Hyde, you look at the reports of Mr. Whiffen, they all say they received a full file system image of extracted data. So step 1 in the methodology that everybody agrees to, everybody agrees that occurred. Number 2, verify hash signature value of image file of data received. This is very important because hash values with regard to forensic data is extraordinarily important for it to be proper because it's the signature, the fingerprint that allows data forensic examiners to be sure that the data that they're giving is sacrosanct. It is not possible for manipulation. The Commonwealth just said that Mr. Green has hurled several accusations without a basis, one of which regards the potential for manipulation of data. And it's remarkable that there is even an issue about this dispute. Mr. Green did put in his affidavit an unprecedented situation, and it is this. Mr. Garino, Trooper Garino, in his April 2023 report, which is an exhibit to our opposition, states that when he got the phone of Ms. McCabe, he used Celebrite UFED, a tool of Celebrite, to image the phone. And that's all he sent to the defense in the beginning. Why is that unusual? Because what happens in every case, without exception, is that the law enforcement sends the raw image, original data that has the hash signature on it. And the hash signature is an algorithm that produces, they call it, in this case, SHA-256. What it is it's a stamp of reliability that says, as soon as we got this data, we immediately processed it the proper way and put a hash signature so that there can be no contest. What the Commonwealth fails to tell the court, Your Honor, is and that leads any proper data forensic investigator to question the integrity of the data. If you turn to, Your Honor, Mr. Whiffin's very long December 2024 report, which is Exhibit 1 to the Commonwealth's motion on page 3, and I'm going to read it verbatim. This value is talking. Here's the key point. However, this requires authentication of the original hash value, which is not possible with Gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication. That's all a fancy camouflage way of saying, Mr. Whiffin saying, I can't validate this hash value because of the way Trooper Garino processed it. Do it, Mr. Garino, Trooper Garino, the right way when he got it. And why is this of concern? Add to this point that's conceding that the hash value in this data cannot be validated. How did the defense get this? When Mr. Garino used the Celebrite UFED reader, all he turned over in the beginning was the UFED reader report. He didn't turn over the data, the full. So Mr. Green had to ask for the data. Then what happens, misstep number 2, Trooper Garino only provides a PDF of the hash value. He used Gray key, which was a mistake, because Gray key, you can't get the original hash value. Mr. Green had to go back a second time and say, no, we don't want just a PDF. We want the full extraction. Finally, after the second time, the defense got the full extraction. And that's when we discovered that the validation was improper. It's not Mr. Green that is coming up out of thin air with these issues. This is the job of a data forensic person. And the first principle is to see whether the data is valid. So not only does Mr. Green justify in his affidavit why there's a big concern over this, Mr. Whiffin concedes it on page 3 of his report. That starts, and I'm going to get to it, all the concerns now about the data and deletions. But that's the foundation for it, and it wasn't caused by the defense. It was caused by Trooper Garino, who didn't do this properly. And with regard to the methodology, I want to go back to Exhibit 1. So, importantly, Your Honor, 1 through 4 of this methodology is undisputed by all of the data forensic persons. Mr. Whiffin, Ms. Hyde, and Mr. Bean all agree on 1 through 4. They all agree that this is the methodology. Number 3, once you get the image of the file, each examiner saves the image to their lab storage system. Some use computer servers, some cloud storage. In 4, the methodology, you then process the data with appropriate tools. Nobody disputes that Cellebrite Physical Analyzer and Magnet Forensic Axiom are 2 of the many tools that are available to use. There's a dotted line that I've put there, Your Honor, because 1 through 4 is undisputed by all 3 data forensic examiners. Number 5. And 1 through 4 is usually all one needs to do as a data forensic examiner. But Mr. Green went on to do more. Number 5, further processing of data as warranted, and he explains why it's warranted here, with additional tools. So he then went on to use Sanderson Forensic Browser, ArtX, Belkasoft X, and then he didn't use iLeap, Ms. Hyde used iLeap. So it's important to line up the methodology. I just don't understand how it can be stated that there's no methodology stated. Not only does Mr. Green state it, we prove undisputed that everybody agrees this is what the methodology is. And that is what is so flummoxing as to why we're even here, because the methodology is agreed upon. What is disputed, Your Honor, is what are the opinions from when you apply the methodology and you apply these tools. So, interestingly, it is Mr. Whiffen who provided the most lengthy report in this motion. Mr. Whiffen only used 2 forensic tools. He only used Cellebrite Physical Analyzer and his own software, ArtX. That's it. What I'd like to, Your Honor, is ask if I could, please, if you could turn to Exhibit 2, which is entitled Digital Forensics Products Tools Used by Witnesses. And I just want to make sure Your Honor has that.
Okay.
So I prepared this demonstrative exhibit to show the tools that all parties used. And the purpose of this is to show how closely Mr. Green and Ms. Hyde match up with the tools used, and how insufficient Mr. Whiffen and Mr. Garino are. So if you look in the left-hand column on Mr. Green, and I color-coded it to try to make it easier, you see 7 tools used by Mr. Green. You see 6 tools used by Ms. Hyde in May of 2023. Many of her tools exact same as Mr. Green. You see Mr. Whiffen, who used really 2 tools, but to be conservative, I listed them as 3 because they're just different versions of Cellebrite Physical Analyzer. And then Mr. Garino, Trooper Garino, used 2 tools. But here's what's really important and I think remarkable that springs from this chart. Mr. Green did more, had a more encompassing and comprehensive review than any of the witnesses here. And back to Exhibit 1, he did 2 more steps in his methodology than everyone else. So 1 through 5 of the methodology, everybody did. 6 is analyze overall user activity, artifacts of interest, timelines of interest, and anomalies such as deleted data. 7, reporting as appropriate pertinent artifacts, other artifacts. For this motion, Mr. Green did 6 and 7, and no other witness did that. The issue in this case as to whose interpretation is correct is an opinion issue. It is not a methodology issue. And Mr. Green makes that very, very clear in his affidavit that the difference is in opinions. Interestingly, on the very key subject of whether the artifact and the interpretation of it is a difference in methodology, a difference in application of methodology, or an opinion, which is not the subject of a Daubert Lanigan hearing. Opinions are not. Here's what Mr. Whiffen had to say about the issue. This is Exhibit 2 to our opposition. It's the June 17, 2024 testimony of Mr. Whiffen, page 1-10, starting on lines 14, the question. And what, if anything, did you find with regard to the web history artifacts? Answer, this is Mr. Whiffen. So the 2/27/40 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record. But the interesting thing was why the timestamp said 2/27/40. And I did some testing on this and discovered the reason why 2/27/40 was actually listed in the database, even though that's not the time. Here's the key, in my opinion, that the search was conducted. So Mr. Green's opinion is, after applying the methodology that everybody agrees to, after using the same tools as every other witness for the Commonwealth used plus more, Mr. Green's opinion is, to a reasonable degree of scientific certainty, that search and that record that everybody saw at the time of trial at 2/27/40, House Long to Die in the Cold, Mr. Green says it means what it says. The search occurred at that time. Now, the Commonwealth, in its recent reports, and they did this also at trial, they said, yeah, we see it. It's in there. Ms. Hyde said, I see it. It's not only in there in Cellebrite Physical Analyzer. I used Axiom, just like Mr. Reed. Mr. Whiffen didn't use Axiom. Ms. Hyde said, and I'm going to point to it specifically, Axiom shows it as a 220, that search is a 224. In fairness to trying to get the best decision for Your Honor here, they disagreed, Mr. Whiffen and Ms. Hyde, as to whether that meant the search actually occurred at 2/27/40. That's the opinion that's disputed. So in fairness to the issue and accuracy, those witnesses diverted at the end as to whether what that timestamp showed, 2/27/40 a.m., did the search really occur then, or as the Commonwealth said, did it occur at 6:23 in the morning? Mr. Whiffen says it's a difference of opinion because he says it's my opinion. The Commonwealth in this motion tries to make it seem like it's an issue of fact, and that Mr. Green doesn't have any fact. Well, Mr. Green's got a lot of facts, and he also, of course, has an opinion. So what we have from these two demonstrative exhibits, Your Honor, is a statement of the methodology in Exhibit 1 that every witness agrees to. Not only is it Mr. Green put a methodology, but we prove up in the opposition that there's no dispute. What's interesting, Your Honor, and I think quite remarkable, is that neither Mr. Whiffen in his 40-plus page report of December 24, nor Ms. Hyde in her December 24 4-page report, neither one of them say Mr. Green's doesn't have a methodology. They don't say we dispute his methodology. It's the Commonwealth's attorneys that are making that dispute. And that is not appropriate. It's got to be your expert. And I think there's a reason why the experts of the Commonwealth are not talking about methodologies or saying there's a dispute, because it's objectively verifiable that there's not a dispute over the methodology. What is also important is what has happened since the trial. And what I want to do is give a baseline of the trial, because I think it underscores the two issues that Your Honor have in front of you: qualifications and methodology. And the qualifications, all I'm going to say about that is Mr. Green has 25 years of experience in computer forensics, and he has 18 years in digital forensics. And the 18 is only because digital forensics became a thing 18 years old. There can be no dispute, and I think that's why the Commonwealth didn't really say anything about it, is because if you lay down Mr. Green's experience next to Mr. Whiffen, Mr. Green testified 23 times as a qualified digital forensic expert in 7 different states. Mr. Whiffen, he's testified in 2 states, one of which was here, and he does not have anywhere near the years of experience. Here's another very important point: certifications. Mr. Green lists 3 certifications. He lists an enormous amount of constant updating. And I just want to state a point about digital forensic experts. They're not like medical doctors where you see people with PhDs, etc. These are folks that keep updated because the computers change so much. So that's why you see such a great listing of Mr. Green in terms of his training in certificates, etc. However, if you compare Mr. Whiffen's qualifications to Mr. Green, and I'm again going to use Mr. Whiffen's own words with regard to his qualifications on his June 7th, this is again Exhibit 2 to our opposition, his June 17th trial testimony, page 1-6. Question, and this is a question from Mr. Lally. Now, with regard to your education in this area, what, if any, certifications do you have? Answer, no specific certifications. I've done the Celebrite coursework since joining Celebrite, but other than the 3-week course in Ottawa, and then again the 2-week course in Ottawa, those are police training things when he's a policeman. I don't have the SANS training or any of that kind of training certifications. Now, I am not here today to challenge Mr. Whiffen's qualifications, but how could it possibly be asserted that Mr. Green's not qualified if these are the qualifications of Mr. Whiffen? With regard to what has changed since the first trial, and I think this is incredibly important with regard to the methodology inquiry of Your Honor. I went through on Exhibit 1 the methodology that everybody agrees to, but the court doesn't have to take my word for it on this demonstrative exhibit, because Ms. Hyde gives the best explication of the methodology that Mr. Green used, because she used the same one before trial and at trial, but she's now narrowed it for purposes of a report, and I'm going to state and show exactly how. So Exhibit 4 to our opposition, Your Honor, is the May 2023 Digital Forensics Analysis Report of Jessica Hyde. And in that report, on page 3, she talks about, under forensic analysis, that she used, it's the exact same methodology.
What are you, I thought you said Exhibit 4. Exhibit 4 is a transcript. It's a transcript of Ms. Hyde, but it's not a report.
Okay, my fault, we have different numbering, but I'll go to the transcript. I'm going to go to the transcript with regard to it. So
I'm happy to look at the report if that's what you're referencing.
I'm
but
going
where
to
do I
go to the
find
report
it?
next, but if Your Honor's already at the, I can do it either way. If Your Honor is at the transcript, I'll go to the transcript right now. This is the June 14th transcript, Your Honor, of Jessica Hyde.
Yes.
Thank you. So we're just, and please keep in mind that in Mr. Hyde's 2024 report, that Mr. Whiffin's report that is now before you, Mr. Whiffin only used in his analysis now Cellebrite Physical Analyzer and Ardex, his own tool. He only used 2 tools. Ms. Hyde, in her 2024 report, which I will get to, is now down to just using 1 tool, Cellebrite Physical Analyzer, because she states that's the only one I was asked to look at. So the Commonwealth went and narrowed the request of Ms. Hyde to just Cellebrite Physical Analyzer. And what is going on here? It's very obvious. The Commonwealth is ignoring in its 2024 December reports all the other tools. Even though those tools show this timestamp of 2/27/40 still, at that time, they now just ignore it and go to the Cellebrite Physical Analyzer. That it's undisputed that Cellebrite went back and changed it in the middle of the first trial with regard to one physical analyzer program. And then after the trial, the other physical analyzer program, they went and changed that and took it off. But in contrast, Axiom, that Ms. Hyde used before, still shows the timestamp. It's undisputed that that's the case. And it's undisputed because they don't contest it, that Mr. Green went and looked at it in Belkasoft, Sanderson. He did a manual, he did a low-level analysis, and in every one of those tools, the timestamp still occurs. So now back to the transcript. Your Honor, I am looking at, the question of, and this is, again, a significant point, is it better to use more tools? It's common sense. That's what Mr. Green says. That's what Ms. Hyde did the first time, but now all of a sudden she's down to just 1 tool that unilaterally removed the timestamp. So here is the page of the transcript of what Ms. Hyde had to say. Page 1-13, Your Honor.
Okay.
Line 4, question, again, of Mr. Lally. Now, with reference to the tools that you use that you just went through, are those fairly common tools? Are those tools that are commonly used within your industry? Answer, yes. And what are those tools that she talks about above? Starts on page 1-2. Cellebrite Physical Analyzer, Magnet Axiom, Artex, iLeap, and I later used Sanderson Forensic SQLite. Those are 4 of the tools that Mr. Green used, and he used more. So her answer is, now with reference to the tools, are those tools that are commonly used within your industry? Answer, yes. They are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. It gets better for the defense. Next question, line 15. So different forensic tools, question, and why were you using the different tools? So different forensic tools have different capabilities and look at data a little bit differently. Skip down. Commercial forensic tools that they can only support so many applications, so they each work and support different bits of data. Here's the key point, line 22. This is Ms. Hyde's words, under oath. So it's important to use multiple tools so you can see the results from different data sets and be able to compare those results and enhance those with manual analysis. Next page. Question. And with respect to, and this will be the last question and answer, and with respect to using those sort of different variety of tools, Cellebrite to Axiom to Artex, etc., is that something you typically do as far as your normal process of documenting a forensic analysis? Answer. Yeah, that is very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretations from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent. And down below, he asked, can you explain the interplay of these tools in analysis? And her answer is strikingly the same as Mr. Green in his affidavit and in our opposition. Her answer, the Sanderson's tool, which Mr. Green and Ms. Hyde used, but Mr. Whiffen didn't, is meant to look at specific type of data structures called the SQLite database. SQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Mr. Whiffen didn't use the Sanderson tool. So here we have Ms. Hyde, and in her report of 5/23/2024, her first report, and I'm going to get to her report here, she basically goes through and documents this methodology, and she documents the use of those tools. And she also documents that she saw the House Long to Die timestamp 2/27/40 in every single tool that she used. Where she diverted from Mr. Green was her opinion as to whether that timestamp meant the search occurred at that time or did it occur sometime later. That's an opinion issue again, and Mr. Whiffen agrees it's an opinion issue in that regard. So now let's come to where we are for this motion and what was submitted by the Commonwealth. And I want to first go to the report of Ms. Hyde now. It's Exhibit 4 to the Commonwealth's motion. And it's entitled Digital Forensics Analysis Report. And there's been much said in the Commonwealth's argument this morning about allegations made by Mr. Green, which are all supported. Every single one supported with facts. But what the Commonwealth didn't tell the court is what the request was of Ms. Hyde. I just went through all the tools she used, why she used them, why she said it's best practices, why you use all these tools. What does she do now in December of 2024 to assist in the myopic approach of the Commonwealth to say, here's our studies, we only look at Cellebrite Physical Analyzer, and it's gone, the search is gone, right? And we know why it's gone, because Cellebrite, Mr. Whiffen, concedes that he went back and talked to the researchers, and what we have, Your Honor, is a total black box. And I'm going to point it out in a moment. Why is this no longer appearing on Cellebrite Physical Analyzer? We don't know the answer. All that is stated is a bald conclusory statement that it's no longer reliable. That's it. We don't know why it's no longer reliable, but we know it's gone. And Mr. Whiffen never says, even though it's gone in one, he doesn't even address the other 4 or 5 tools where it still appears. It still appears. Now to Ms. Hyde. Disquietingly, on page 3, look at the request, please. The request was to understand changes made in newer versions of Cellebrite Physical Analyzer to artifacts pertaining to the timeline of a Google search on January 29, 2022, namely House Long to Die in Cold. That is stunning. The request to her was simply to look at one tool that everybody knew by then Cellebrite had deleted in their program. She then looks at evidence analyzed, second paragraph. This full file system image was processed with Cellebrite Physical Analyzer, version blah, 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 decoding engine, etc. Where is her analysis of Axiom that was in her May 2023 report? Where is her analysis of Sanderson? Where is her other analysis that if she went and did it, she would have to say it's still there? So what she goes on to say is very interesting, but it's buried, and here's what it is on page 4. After she goes through and states what everybody knows is Cellebrite just went back and for some reason deleted it, she says under the chart, while manual analysis of the database still shows a 2:27:40 a.m. ET timestamp, the determination in prior analyses and from Celebrite is that this timestamp does not demonstrate that the URL was visited at the time of the last visit timestamp. So here she did a manual analysis and it still shows up, but she doesn't explain the significance of that. If we want to talk about reliability, Your Honor, the real question should be the reliability of the prosecution's witnesses in Celebrite Physical Analyzer.
So are you telling me that we should have a hearing?
Your Honor, there's no need to have a hearing, and here's why. There's no need for a hearing because there's no disagreement on the Daubert issues. The dispute over what is the interpretation of this data, what are the people's opinions, is never one for Daubert. If that were the case, there'd be a Daubert hearing on every expert because experts, almost by definition on each side, disagree on the opinions. We don't need a hearing, Your Honor, because they agree on the methodology. They agree that more tools are better. They agree that the difference is at the very end of the analysis, which is the opinion. So in terms of the issues with regard to Mr. Green's report, which is my final point to get to, there's been so many mischaracterizations by the Commonwealth this morning of what Mr. Green did and what he said. So what does he do? He says, and Your Honor, digital forensic analysts are the equivalent of a medical examiner. Their job is to apply the methodology that is agreed to. Their job is to use the tools, everybody agrees on it, and then they're to give opinions on what those mean. And everybody here has the same data, right? Everyone's got the same data that they're using, so there's no dispute over that. The Commonwealth said that there's no factual basis for what Mr. Green did. There's a factual basis for everything, and it's undisputed. So everyone has the same data, and this I call the NB postulate. And the NB postulate is, why are people using different tools, etc.? Is because nobody has the source code for the Apple phones. So you use these tools to try to help interpret what these source codes mean. And it's an accepted methodology to do it. But the data, once it's produced, and we have an issue about what happened before it got produced, but in terms of the methodology that was applied here in the tools, there is no disagreement. So what, Your Honor, would an evidentiary hearing do? We're just going to come in and have witnesses talk about their difference of opinion? That's not what a Daubert is for. There's no basis for an evidentiary hearing because there's no dispute over the methodology. I've done a lot of Daubert hearings. I've never even gotten past a motion, let alone an evidentiary hearing, where the experts don't disagree on the methodology. So what is it that caused Mr. Green to raise questions? And again, I said data forensic examiners are just like the medical examiners. They don't look at just the body of the medical examiner. They look at circumstances surrounding it and all information. Well, that's what digital forensic examiners do, and that's what Mr. Green did. So there was great criticism of Mr. Green from doing what is proper for a digital forensic person, and it's a bit of a camouflage, respectfully, because the December 2024 reports of the Commonwealth now myopically go down to just one tool. So what did Mr. Green say that caused him to say, I think it strongly suggests that there's been manipulation here? He used the fact that there's no hash value for the data. That's conceded. And when there's an issue over hash value, every single digital forensic expert is going to raise concerns about the validity of the data. And Mr. Whiffen is one of them who did that. Secondly, what Mr. Green pointed out on the issue of was this search deleted, There were 4,056 searches on the phone of Miss McCabe. 4,056. There was one deletion out of 4,056, and guess which one it was? House long to die in the cold. There are no odds that that can happen randomly, that one search out of 4,056 is deleted. So what does Mr. Green say? He says that strongly suggests one of two things. Either there was user interaction deletion, or there was post-imaging manipulation of the data. He doesn't accuse individuals. He says user interaction or post-imaging. That is the job of a digital forensic person, to point that out and say that raises concern. The fact that there's only one deletion of a search out of 4,056, I think it's malpractice if a digital forensic examiner doesn't point that out. Another key thing he points out is an anomaly. The Commonwealth said there was a tab number for Hockomock Sports, in that they said it was the same tab number for how long to search or how long to die in the cold. But Mr. Green points out that's incorrect. They had two different tab numbers. So that theory of the prosecution can't be right. So Mr. Green wasn't hurling accusations. He was doing what data forensic examiners do, is pointing out all these anomalies. These aren't things you normally see, and they're not explainable. Here's the last point I'll make, which there's also agreement. There's this deletion of this one search. Mr. Whiffen can't explain why. He says, well, maybe it was a spontaneous deletion. There's no such thing in data forensics as spontaneous, and he doesn't cite any. Maybe it's because the search didn't load. Maybe it's because there was bad connectivity at where this search occurred. Well, that's interesting, because a harder thing to load, the image that came up with food, did load. So you got to have stronger connectivity to get an image that dense. So what Mr. Green simply points out is that doesn't make any sense either. That is the essence of Mr. Green's affidavit. And Your Honor, just to be clear, when we sent in the second affidavit of Mr. Green, we put in the cover, and Your Honor may not have gotten this, that it was to replace the first affidavit because there were some typos, et cetera, et cetera. So you'll see two dates of the affidavits, and it's the later date, and I'm going to give you the specific one that controls.
No, I have both.
Okay, right, yeah.
The second one on the body of it does not say it's a supplemental or anything. If it was in the cover letter, that's what, they're both docketed, so they'll both remain
I was
docketed.
just going to say, we wanted to have them both there for whatever purpose Your Honor wanted, but there's been some question about why two, and it's a simple explanation, one supersedes the other. So Your Honor, in terms of, and this will be the concluding part of my remarks. In terms of the allegation that Mr. Green relies upon technical support at Axiom, and he relies upon technical support of Axiom, and the statement that is just remarkable, that that's the basis for his expertise. Mr. Green makes very clear that he did his own analysis. He used the tools himself, but here's why he called Cellebrite. At the time of trial, Cellebrite had two versions of Physical Analyzer on the market at the same time. One Physical Analyzer 7 showed the 22740 timestamp. It showed it, and it showed it in a deleted state. But the recent one, the one that Celebrite updated 1 week before trial, didn't have it. So that was the Insights, spelled oddly, INSYEDES. That didn't have it. So Mr. Mr. Green did what any good digital forensic person would do. He called up support and said, well, you know, what's going on here? You got one that shows it, you got one that doesn't. But he did what the NIST standards, the National Institute of Standards, and that's attached to Mr. Green's affidavit, says that good digital examiners use multiple tools, and when they have questions or they see anomalies, you call up the program people, you talk to their technical support. That's not someone inexperienced and relying upon them. That is the proper methodology. So Mr. Green did that to corroborate and get explanation for what he found. So in sum, Your Honor, here is what is before the court and what is pertinent for this motion. What is pertinent is the inquiry under Pope, which Your Honor cited in your decision on Dr. Russell. It comes down to, is Mr. Green qualified? There's not even a contest. Second, is his methodology reliable? And Your Honor, those are the only two subjects that are ever proper for a Daubert hearing. Why would we have what will be a very long hearing? Now, Mr. Brennan suggests bringing in Mr. Whiffen. I've never heard of that happening in a Daubert hearing, where one party challenges the witness of the other and then says, and oh, by the way, I want to bring in my witness to show. That never happens in Daubert. It's the person who—
I wouldn't say never.
Well, let me take that back. Good point. I won't say never. It is so unusual to have that happen under these circumstances. And this is the key, Your Honor. Why would we have a hearing about whether his methodology is proper and reliable if all of the witnesses agree what the methodology is? So, Your Honor, in conclusion, I would urge the court to deny the motion of the Commonwealth to exclude Mr. Green on one of 6 data forensic issues. He's going to be testifying, obviously, at this trial. And I would urge Your Honor to not have the evidentiary hearing, because Your Honor has before you everything Your Honor needs to perform the gatekeeping function. And again, it's almost all undisputed with exception of one thing, and that's the opinions of the expert, which is never proper. I will respectfully state that never is appropriate for a Daubert hearing. Thank you, Your Honor.
Okay. Any follow-up, Mr. Brennan?
I do. A little bit of knowledge of forensic data analysis can be dangerous. So when you hear representations or arguments that Mr. Whiffen's opinion that there may have been a connectivity issue is undermined because there was a picture of food which is suggested through a application search, misunderstands the basic premise that that's a cache picture. And that is meant for the user of a phone, for the user experience. And so there is cached items that are available without connection that register and come up quicker from a different source while it's waiting for a search to be conducted. It's simple, it can be explained, it's science, it's data. So when you take a little bit of data and you twist it because you misunderstand it or you want to advocate, that is the danger, and that's why it's best left to experts. What the defense apparently is mistaken about is that using a number of tools does not substitute for methodology. You can use one tool, you can use 30 tools. They're all going to say on the timestamp that how long to die in the code occurred at 2:27 on that browser. That is the time that was open. That window was opened at 2:27. But you can't just look at 8 different tools that are all going to say the timestamp is the same. You have to look into the data and into the databases, knowledge C, the history, and you have to determine what artifacts exist to show that occurred at that time. And when you do that in this process, it is clear that 227 search happened after 6 a.m. in the morning. And so that's what Mr. Green doesn't do. He doesn't engage in methodology at all. There's an agreed methodology. He doesn't use it. The defense points to Ms. Hyde's report, how it's narrow. It's narrow because it's in addition to her 2023 report. Mr. Green has not written a report. He has not provided data. He has not provided that he has used methodology. He has not engaged in the process of studying the data. He made a couple of phone calls. And so you can't simply look at the timestamp and then give a reckless opinion not based on the methodology. We still haven't seen a report from Mr. Green. There is none. Because if he actually does the testing and takes a phone and tested his hypothesis, he would dispel his own hypothesis. And if he doesn't do that, we'll do that for him. There is no hashtag concern. And when the defense raises issues, postures, ideas, we never hear what the problem is. What is the hashtag guy? Who manipulated it? And that is the MO. Blame anybody. Don't articulate who. Be like a ghost, evasive as possible, and then when it gets knocked down, just posit a new theory. The government offers to bring in Jessica Hyde next week or in with them at another time. Is it common? No, it's not. It's because the government has no fear of a hearing to help educate the court on the data science that is at play here. And so while we don't need to, we have no reluctance to. So there is a real accuracy on the fallacies that Mr. Green promotes in this case. And so we're happy to do it. We welcome it.
Okay. Did you want to say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your
Okay.
Honor. Thank you for the opportunity. The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right. With regard to the whole premise and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth foreman. What was said, it's alleged that Mr. Green has reckless opinions. My point exactly, take away the reckless. They're going after his opinions, and it's been stated now by the Commonwealth itself. It's the opinions, and those are not proper for a Daubert hearing. Thank you, Your Honor.
All right. Well,
There are 4 exhibits that have been won.
thank you. So it sounds a lot like it may just be a disagreement in opinions, but for the Commonwealth, I will look more closely at your methodology arguments that were made today. If I decide that we need a hearing, an evidentiary hearing, and that I cannot decide this motion based on everything before me, I will let you know no later than Monday. Okay? So we'll keep
Yes,
next
thank you.
week and I'll let you know. All right. So, and not that I would exclude something simply because it takes a lot of time, but we really need to make sure we keep this case on track for the April 1st trial. So I have a question for the Commonwealth on where we stand in discovery. And then we're going to talk a little bit about the motion to recover expert-related expenses.
Your Honor, we've been producing discovery as we've gone along to try to give the defense as much notice as we can. I had anticipated having discovery finished last week. We've sent over most of our discovery last night, or is in the process of being turned over. There was one further report. We've retained Dr. Wolf as a neurologist. I'm waiting for his report. He is away. And so my expectation is I can have that report by Wednesday.
Okay.
Further, there was a witness interview earlier in the week. I'll have that report as well. My Rule 14 commitments are ongoing. They are involved. enormous amount of time over the months has been spent trying to satisfy that I can account for all the discovery and make sure the defense gets everything that I can as soon as I learn about it. We'll continue to investigate this case all the way to trial, but our discovery should be completed by Wednesday.
Okay. Does that include the analysis of the data from the Lexus?
That has all been turned over, or we're sending it over on link. There's something like 8 gigabytes on my expert, so it takes a long time to download. It was all sent to us yesterday. That's all included.
All right.
The analysis is done. The accident reconstruction is done. Mr. Crosby, with expertise in bites and dog bites, his reports are in. Ms. Hyde and Mr. Whitman have further reports that have been provided. Ms. Hyde has one more that's outstanding. We may have it. I expected it last night. I have not reviewed. And I think that accounts for. We've been through the entire amount of discovery that was prior. It's all been Bates numbers. It hadn't been before, and it's marked as previously provided. I've made a very, very thorough accounting analysis with help of all of the information that isn't in those Bates numbers, and provided everything that I've come across as soon as I come across it.
All right.
Continue to look through all of our materials. There was an issue regarding a phone that we hired a third party to look through the phone and produce all Rule 14 discovery. I mentioned that my position was that it was a very broad view that the assessor should look at. I was uncomfortable reporting to the court that the phone had been reviewed by somebody else, so I did it myself. And so I've gone through the entire phone, every email, every page, thousands, and I've provided not only Rule 14, but broad discovery. This went to a protective order this morning to the defense, so they have anything that, from my perspective, from my experience, would be remotely important or interesting to them. Also, I've gone through well beyond my obligation emails of members of the District Attorney's Office, and that continues, and I have another reduction as well. I wouldn't call it Rule 14 because it's not necessarily statements of witnesses, but again, I've taken a very, very liberal and broad view of what I would potentially want if I was defending a case. And I've provided that again under seal today.
All right.
And so we do not have an official discovery order, but I'd like the defense to have their discovery meet 30 days after I complete mine, which will be next week.
Okay.
We filed, but I did not see on the docket, or we sent in, we did not file a motion for clarification, and Your Honor did not mention that as an important notice that we had sent in, because I am greatly respecting the April 1st trial date, and there's work to be done. And so I would like to address that motion to clarify when appropriate with the court.
Okay. All right. I'll need some time to review this, obviously.
Yes, Your Honor.
Okay. All right. That's great. So the Commonwealth expects to be ready for trial April 1st.
Yes, we do.
Okay. All right. So now let's just take a look at a preview, if you will, of the defendant's motion to recover expert-related expenses from the Commonwealth. Okay. I see there's a written opposition that I just received. We're not going to hear this motion today because I didn't have the opposition. But one of the things that I'm hoping you can tell me before we hear this, all right, there are a couple of things. Let me just, in this motion, there's a footnote that references, so this motion from the Commonwealth was filed, from the defendant was filed on January 23rd. So more than a week ago, and the motion, I believe, is a footnote that highlights a pending motion to dismiss. I need that motion to dismiss. We need to get this moving. When will that, well, I'd like that filed next week so we can hear it next week.
The reason that we haven't finalized it, the reason we haven't put the full contours on that motion is because we haven't received all the discovery. And I think it would be premature for us to figure out exactly what the parameters of our motion to dismiss are until we know exactly what the Commonwealth is putting in front of us in terms of the second trial. But as soon as we get that, we think that we have the grounds to bring that motion relatively quickly thereafter.
So you expect to have everything to the defendants by Wednesday?
I do, and really what's missing is a report from a neurologist, a witness interview that is really inconsequential. And Ms. Hyde has a report regarding a phone. That's all that's really left for discovery. So that's all I can say.
All right. So if you get it by Wednesday, we're here Thursday and Friday. I'd really like to see something by Friday. You've obviously been working on it, even if we end up having to do it in piecemeal. So
We've been thinking about it, but we have not, I don't know what you mean by working on it. Yes, obviously, we're working that direction, but Your Honor, there's no way for us to reasonably get that done by Friday. That's just, there's so many other things that we're dealing with, including hearings like this that keep coming up over and over and over. I'm not, the court knows we don't drag our feet. As soon as we get something, we act on it. I just can't promise that we could get it done by Friday. We are working on it, and we're not.
So
there's no strategy for us waiting. I promise you.
be prepared to discuss it next Friday. I will be looking for it very shortly thereafter, and we will have a hearing on it very shortly. Time to respond.
Understood.
So we need to come up with a scheduling order, or I've got a scheduling order that we need to discuss. But regarding this motion, what I need to know before I hear the motion on the expert-related expenses is what sort of protocol you all worked out. Maybe it's in the Commonwealth's opposition that I just saw. What sort of protocol was worked out? Who was notified, what the arrangements were, how this all was set into play, and why there was a violation.
I can certainly brief that for the court. We addressed it pretty significantly in our motion in terms of the conversations that were had, the expectations that we had, the protocol in terms of getting our expert out there from Arizona.
No, what the agreement was, right? People don't just show up for the other side's expert. I just need to know what the agreement was for your expert to view this on that date.
Most of this was reduced to email. I think it'd be
Okay, so
probably
put
a little
it,
bit more accurate for me to just go back and file a supplemental brief.
yeah, so
Probably
I need all that information from such egregious conduct.
Sure, okay. I'll submit that won't take very long and I'll.
Because then we'll address this next week.
Okay, that's fine.
All right. If we do not have an evidentiary Daubert hearing, do we need both days? Or does it make sense to schedule everything for Thursday? What's the Commonwealth's position on that?
Absent that, I don't think there are a lot of matters before the court. The motion for clarification should take probably less than 20 minutes.
Okay.
And the motion for fees is a very simple discussion. So I don't think there's any way we'd need 2 days unless there is actually an evidentiary hearing, and then it'll take some time.
Okay. What do you say, Mr. Jackson? You're nodding?
I agree. I think if there's an evidentiary hearing, it's going to take multiple days. If there's not, I think we can pack everything in Thursday.
All right, because I don't want to waste everybody's time. I want us to get this case moving.
Of course.
So you will then file that motion to dismiss the following Monday or Tuesday, and we need to set it up for a hearing. If you are indeed filing a motion to
I'm sorry.
dismiss.
The motion to dismiss on which Monday or Tuesday?
After we meet next
The
week.
following week.
Yes. I just want to get a scheduling order going, so I need some of these dates because we're going to need to schedule a hearing on that. I do not anticipate an evidentiary hearing on that, but I expect it will take time. All right, so the Commonwealth will have all of its discovery to you, it expects, by Wednesday, the 5th.
That's correct.
Okay. We'll be back here at the end of next week. After you have that discovery, I can give you until February 11th, the following Tuesday, to file a motion to dismiss. And Commonwealth, I'll give you until the 14th to file an opposition to the motion to dismiss. And let's hear it the following week. We're also going to have to, does the defense anticipate any evidentiary motions?
Yes, but I can't tell you exactly what those are, but in an abundance of caution, given the fact that we're expecting new information from the Commonwealth, I think the court can
All
safely
right.
say yes.
So February 21st, and I'll put this in writing. Filing of all evidentiary motions that can be an out of court date unless we choose that day to hear the motion to dismiss. Why don't we figure out what's your availability the week of the 17th? The 20th is actually the best day that week for us.
Your Honor, that is, that week is school vacation week. Both Mr. Jackson and I have young children, but one of us, I think, could probably be here on the 18th.
On the 18th?
Right.
Yes, Your Honor.
Okay. Well, all right, so I'd like you to get me, can the Commonwealth get me the opposition by midday on the 14th? So I'll have it to review over the weekend. I know you haven't seen it, so it's hard to figure out how much time you need. Is the Commonwealth available on the 18th?
I'm available anytime.
Okay.
I mean, we'll put all our effort into it. If we have a problem, we could let the court know.
Okay.
We'll do our best.
Okay. All right. Okay, so the 14th will be an out-of-court filing date. The 11th, an out-of-court filing date. So the motion to dismiss hearing will be on Tuesday, the 18th. Filing of all evidentiary motions will be the 21st. And that will be an out-of-court date. We will do the hearing on all evidentiary motions March 4th and or 5th. I'd like you to block off both days at this point. And if we don't need them, we'll try and, I don't want everybody coming in for just one motion. I know how much work you all have to do to get ready for trial. There's a lot of work I need to do to get rid of trial, but I'd like you to block off those 2 days because we can't have motions to suppress going on and on past that date. I'm going to need some time to review them and write them. So, all right. Can you all come back in on March 7th? You'll file all motions in limine. We'll have a final trial conference. And then we'll have to set up a date for what I anticipate will be at least a day, maybe two, because it was last time on motions in limine. All right, so March 7th will be an in-court date. And file all motions in limine. And at that time, I want you to tell me how long you expect your motions in limine to take.
Your Honor, do you want those filed by the 7th? All motions in limine filed by that hearing date, the 7th?
Yes. And on the 18th, which only gives me 2 weeks to decide them. Because we're starting the trial on April 1st. Jury Commissioner's Office has been fantastic about it, getting us as many jurors as possible. And we'll talk about impanelment, obviously, a little bit later. All right. All right. Anything else we need to discuss today?
Not on behalf of Ms. Reed, thank you.
No, thank you.
Okay. All right. Thank you all.
You are muted. Goodbye.
The Muhammad Ali.
Hi, Kevin.
Hey, Ken, just let it go for a second, see if anything interesting happens. Let me turn the volume down on the. Okay. I don't think we need any volume on that. We can just watch them a little bit. So there was a lot of interesting stuff there, Jen, huh?
Yeah, I thought so. Also, it's going to be interesting. The biggest takeaway I had was it seems like the judge may not entertain a Daubert hearing, which doesn't make a lot of sense to me. So I'm wondering if the defense point that Daubert should never be about opinions, but should be about competency about the witness. I wonder if that's in play from perspective.
Yeah, you hear a lot of talk about methodology and whether there was one, but I think it's reasonable that there was a methodology on Rich Green that was probably not all that different than what the other people do. You run these programs that test the equipment. I thought Alessi was effective, but these are common arguments. I think, this is not just new to data, but the idea going back since the history of trials is that the defense gets to bring in their expert witnesses. And, we want them to have that, the defendant to have that right. But what do you do, as we talked about beforehand, when they're shopping around for experts that are making a lot of money just going on? There's a lot of reasons to besmirch this guy's credibility. I don't like to make it personal because he's not a witness. He's an expert, and he feels very much like the character Slippin' Jimmy to me. And he's basically Slippin' Richie. I don't know. But how do you prevent that in a trial? Because he is going to create doubt for some jurors. So, I think maybe some jurors understand that, just common sense wise, and I think this happened in the last case, that defense teams find these people. It's just nature of the beast.
They find them, and I think it's interesting, as I've said, Dr. Russell, they were never able to find anybody in the dog bite community. Dr. Russell came to the defense, which is a key situation.
In the middle of the trial.
At the end of the trial. Actually, they were sanctioned, at least verbally. The judge admonished them that this was absolutely a discovery violation, because you can't, in the middle of trial, just, now all of a sudden we have a witness, because it doesn't give the prosecution time to cross and time to look at their accreditation, etc. So, it was a big problem what they did. She allowed her testimony. I've said this over and over again. I think her testimony with a reasonable juror will only hurt the defense. I've said that over and over again. And I think the prosecution getting a dog bite expert, which again, why didn't they have one before? Because I don't think they ever thought once they got the canine DNA, the fact that there was no canine DNA on the shirt, I think they thought, well, this is a done deal, but they just have to keep going further and further steps to discredit the illogical, as you would say.
Mhm. And this is the thing with all of these experts that they found. And I'm going to guess that this is probably common in all of these cases. This is a variation of what Kate said, where they're just looking at a narrow parameters of data, but they know who they're working for. They know what what is required of them, and they're going to. Whenever you come to a road on a particular piece of data or evidence that they're looking at, they're only going to interpret it in a way that's positive to their client. So you have with Dr. Russell, she looks at shallow abrasions on photos of a corpse. And yet she concludes that with a degree of medical certainty, those are dog bites. That's irrational. All right. There's no way any dog bite expert would look at that and based on that alone come up with that kind of a conclusion. You might look at that and say, oh, those could be dog bites. They have those kind of parallel tracks aspect to them or something like that. But there's shallow, we need to know more about the circumstances because there's all kinds of other things potentially that could create those kind of wounds. And she didn't do that. Same thing with the ARCA guys. They had no interest in the text data, vehicle data, which they're experts at. And here with Green, again, you see this guy that is just looking for things that he can use to create doubt, but ignoring everything else. But I think you're correct that it's going to be difficult to try to rule this person out on the basis of a Daubert hearing because that's his opinion. He's entitled to create his opinion, and so the issue is his credibility. And apparently, credibility is not a proper topic of a Daubert hearing.
Yeah, well, it is a proper topic, but the bottom line is, I think, just like Russell, he would be found able to testify based on, I see what you mean, credibility. You're right. More that he's going to be able to, based on his background, he's going to pass Daubert. But I think, a reasonable jury will see through this. But, I think I have too much hope. And the fact that they're drawing the jury pool and there's going to be no change of venue is such a huge defense coup. But Kevin, I have to take off now. Thank you so much for having me.
And everybody, this is Jen Coffenaffer, a retired FBI agent, and her channel is Breaking the Case with Jen Coffenaffer. So please check that out when you can. She does a lot of other cases. Okay, thank you, Jen, for being here. I'm not sure if Kate will be back. Kate's very much in demand. So, and I saw Drunken Turkey here. I'm not sure if I sent him the link, but I'm not sure if he's feeling up to coming on. And I've also sent the link to John Jackson, John's friend who is in court. He's interested in coming on, but he hasn't done StreamYard yet. So, and I don't know he's obviously on his way home too. So we'll see if at some point he can, oh, thank you, Mike. The mic sounds good. Thank you. All right. So unfortunately ran out of time with Jen because there's other questions I wanted to ask her, but there was really fascinating reports from the interaction between Brennan and the feds. And there's more so he said there's more discussion about the TUI process. So does this mean that they've put more evidence into the TUI process, right? Is any of that evidence significant? Is it exculpatory? If they've put any evidence into the TUI process, there is kind of a presumption that it might be exculpatory. Now, let's not overreact to that. So, for example, so just to discuss the way the law works. So if, excuse me, if the feds or any branch of the government has exculpatory information about a defendant that's being charged in another branch of the government. So in this case here, the state of Massachusetts is charging Karen with murder. Sorry, I need a cough drop. So once the way the process works is, so if you're a defendant, you have what's called Brady rights. You have the rights to Brady material. This is any exculpatory evidence that the government has. Now, when one branch of the government has that evidence, that's different from the branch that's trying that person. The way the process works is either the defendant herself or the prosecutor reaches out to that branch of the government and says, do you have any exculpatory evidence relevant for this case? And when they do that, let me just make sure to fix one thing on the screen. When they do that, that branch is required to take. Now, if it's the federal government, they're required to take to look over what they have. And if any of that evidence might be useful to the defense as exculpatory, they put it through what's called the TUI process. And the TUI process is just a process to make sure that anything that is turned over meets the rules of the federal government. So the Norfolk County DA's office, all the way back in May of 2023, when they learned that there was a federal investigation into this, they very smartly sent a letter quickly to the U.S. Attorney's Office saying, if you have any exculpatory evidence about this defendant, you need to give it to us because we're putting her on trial. We need to know. Now, we now know that process, that's them doing that, is more than just them being ethical, which they were, but and saying, hey, we're putting this person on trial. If you got some reason to think that she's not guilty, we need to know it. No, that was also a formal thing. That is a formal step that triggers a process where now the feds have to turn over that evidence. They have to put that evidence into the TUI process. Now, again, so many aspects about what the feds have done here is suspicious. And one of them is that they didn't reply to that letter. Unbelievable. And several other letters refused to reply, refused to say whether or not they had exculpatory evidence. So this forced the district attorney to write a letter to the Department of Justice, which is that's the boss of the feds. The U.S. Attorney's Office is part of the Department of Justice. So they sent a letter to the feds, to the Department of Justice in Washington, and according to the letter that now they replied, and according to the letter that came back, they said that the U.S. attorney in Boston has a different view of this case. However, now this does start to begin the process where you put that evidence into the TUI process and get it over to both parties, which they did late last year. Now, any evidence that they had that could potentially be exculpatory had, by law, to be turned over. So anything that they had developed up to that point, as a result of, all the phones that they got data on, the witnesses they talked to, but a big part of that was the grand jury testimony. So the feds did a grand jury testimony, and that went into the TUI process too, because you have witnesses, multiple witnesses here that testified in the state grand jury and then also in the federal grand jury. Now, if there's any discrepancy in their testimony, which there's going to be, right? But that's up to the defense to decide if that could be exculpatory. Does that somehow impeach the credibility of that witness? So they had to turn that over. So that doesn't mean that anything in that grand jury testimony was exculpatory in the sense that it proved Karen's innocence, but it was something that was useful to the defense, so they have to turn it over. So if there is new evidence at this point that has gone into the TUI process by the federal government, that's been put in that by the feds, that does not mean it's some big thing that proves Karen's innocent or proves there's a conspiracy. No, there's something that they have decided could be useful to the defense. Now, I put together an amicus myself that I called the amicus bartendicus, because wouldn't want, tongue in cheek a little bit, I didn't want anybody to be confused that I have any legal background, which none of you would be. But I wasn't trying to pretend to. But the idea, what I tried to make in the argument there was that if there is, and it was maybe a reach, but if there is exculpatory evidence of the third-party culprits, the feds should have to turn that over too. And the reason I say it now, the defense would say, no, they're not required to. And the U.S. attorney would say they're not required to, because that is not exculpatory to the defendant. it's only exculpatory to the witnesses that are falsely accused, and they're not on trial, so they have no Brady rights at this point. But what I tried to argue was that, look, the defense is complaining about limited resources, understandably, to try. And so part of what the defense is doing is chasing down third-party culprit theories. For example, they argued in the Vanity Fair article that they saved some carpet that was being thrown out, and they're storing it. And does that carpet have any kind of blood evidence or other evidence on it that could be of value? And they said, but they can't afford to get that testing done. Well, what I tried to argue was that if the feds have exculpatory evidence about one of those third-party culprit people that the defense's proposal might be a third-party culprit killer here, that if you can help the defense eliminate that person that they're looking at, then they can focus their resources on someone else. So that's the argument I tried to make. I guarantee the defense wouldn't care for it. But so if, for example, if you had geofence data, if the feds got that, which showed or tended to show that Colin Albert was left in the car with Allie, say at 12:15, so 10 minutes before John and Karen got there. They should turn that over they should put that through the TUI process and turn that over under the theory that now the defense can stop wasting resources investigating Colin Albert because he wasn't there. So that was my argument, that should be put into the TUI process. Now, of course, they should also do the right thing and hold a press conference. Now, Josh Levy's gone, so I guess those press conference days might be over for a while. But in that office, they like press conferences. Hold a press conference and do the ethical, honorable thing and said, we found no evidence to support the third-party culprit theory that's put forward by the defense. And we looked hard into it. But they're not going to do that because it's embarrassing to them. They spent a lot of resources and really, in some ways, violated people's rights to privacy in going after the phone communications that they did. So for them to do that, when it comes out, and it will come out eventually, it makes them look bad. It's embarrassing. The U.S. Attorney's Office was duped. All right. So they don't like to, they are all about headlines. That's the purpose of their job, is headlines. So is it possible that there's something of that nature? But we don't know what has gone into it. Kate's here. Maybe she has some insights onto that aspect of it. I don't know did you hear that discussion, Kate, at all?
I did not. I apologize. I was actually just reviewing the new documents that were filed by the Commonwealth because they had mentioned it during the hearing. So it's been docketed and,
anything to do with the federal materials, and then we'll go back to whatever else you found in those documents. But I was just discussing Brennan's interesting comments that almost seem to imply that there may be new TUI evidence, but I'm not, I'm reading. It's hard to say. He wasn't that clear on it. So what do you think on his comments?
No. So it sounds to me like he put in a TUI letter and they came back and said pretty much, we're not giving you anything more, is what he said,
Right.
that he wasn't surprised by that. So
Okay.
I took the complete inverse from it. It sounds like there are new. No. So the issue here is that they're looking for reciprocal discovery on
Right.
these two experts, right? So that's
Right.
what that was the purpose of the TUI request, was essentially like he said, like, I didn't have to do this. The burden is not on me, but I went ahead and did it anyway, right? I contacted the federal government and said, look, this is what we need from you. And it sounds like what happened is they came back and said, nope, sorry. So this is sort of the crux of the issue that Brennan is bringing up with ARCA for the next trial. Not
Right.
their credibility, not their qualifications or anything else, simply that, they can't comply with the reciprocal discovery demands. So it sounds
Right.
like he's probably going to be moving forward with that. Yeah.
Oh yeah, hopefully that's the case, and it could be something simple like that, or even if they actually do decide to give to give to the state what their original instructions or communications were with the ARCA guys, that would be something that has to go through the TUI process, right? So that would be something in theory new, but it's not really. It shouldn't be impactful.
It sounds like they didn't even get that, though, is what I'm saying.
Right.
Yeah.
So
Yeah.
good.
No,
And so
no,
what did you
no.
learn from the new documents?
So, I mean, it pretty much just confirmed what I already suspected. So, what we have here, sorry, let me actually look at what I was looking at. So there are 2 motions that were filed by Brennan. I did check the dates, so I'm not sure if I would be surprised. Yeah, so it looks like he filed these on the 29th, but they didn't come through until today for whatever reason. So it's the opposition to Karen Reed's motion to recover the expert-related expenses, and then he filed a motion for clarification too. So I was not expecting the motion for clarification. We can get to that afterwards. But the Commonwealth opposition to the motion for expense-related, or expert-related expense recovery. It's only like a 3-page document, and he pretty much says, look, they are not construing the conversation that we had properly here. That's not what happened. So it looks like what happened was, first of all, they never put in a preservation order. And that's important, right? Because 3 years after the fact, you can't complain that the evidence has, gone away in its original raw untouched form when you didn't ask for it to be preserved in the first place, right? 3 years is ridiculous. So that's issue number 1 that he brings up. There was no preservation order for these videos on the DVR. Then he says they made it in November of 2024. The defense made an informal discovery request relevant to additional Canton Police Department videos. Okay, so they pretty much called up Brennan and said, like, hey, you got any more of those videos? So Brennan responded on November 25th, informing the defense that he would inquire of the Canton Police Department and or keeper of the records to identify any potential chain of custody of video footage provided and would request any documentation that may exist relative to chain of custody of surveillance video. Okay, so he goes in and he checks, and it doesn't explicitly say so, but I would surmise that perhaps at that point they're like, yeah, we got these other videos too, right? That clearly don't sound like they were very germane to the case, but Brennan throws them in anyway. That's just me kind of speculating there. So during the week of December 1st, Brennan and Jackson and Yannetti spoke on the phone. Jackson asked Brennan if they would consider allowing a defense expert to access the Canton's police department system. No motion or order has ever been filed relative to the request, but he, agreed to accommodate this informal request. During the phone call, Jackson expressed concern that the video footage would no longer be stored, and ADA Brennan acknowledged and shared attorney Jackson's concern, given the passage of time. So pretty much exactly what I thought, right? I thought one of 2 things had happened. Either they had not bothered to tell Brennan the true reason for why they wanted to go down there. Like, we just want to look at where the cameras are. And they dumped this on them. Or number 2, that they had a conversation like what they had and that was being left out. So that's pretty much the crux of it right there, is like, look, you guys didn't ask for anything to be preserved. It's been 3 years. You were concerned that, these videos might no longer be on the NVR. I agreed with you. Knowing this, you still sent your expert out anyway. Right. And he went through a lot of steps too, Brennan. He met with Chief Rafferty. He received permission for the defense to search for videos through the DVR. Because Attorney Jackson had requested that nobody touch the DVR, Brennan directed Chief Rafferty to advise her staff not to mess with it at all prior to them. So I mean, it's not really preservation, but he did what he could when it was asked of him, right? Right. Brennan also invited the defense to tour the entire Canton police station and note all the camera locations. He informed the defense that they would have a forensic examiner from the Norfolk County District Attorney's Office present. They videotaped the whole time that they were there to memorialize the event. Yeah. And when they came there, and they obviously found out after 3 years that the footage on the NVR was overwritten, it no longer maintained the original surveillance footage, and that was it. Right. Yeah.
No surprise.
And Brennan went a step further too, and he had a discussion with retired Sergeant, I'm going to butcher his name, Diacamente Petria. I can't even say it. So the retired sergeant that was originally responsible for the DVR materials that obtained and produced the video. He actually talked to him and figured out that they routinely would make a copy of footage and then preserve footage on the work server hard drive, which is separate from NVR file system. Yeah. Right.
We did learn today that there was 8 gigabytes of data recovered from the vehicle, and that they will be done with their analysis by next Wednesday. Now, I wouldn't expect that we'll hear too much about that, nor do I really kind of want to, in the sense that you want information to be controlled. But do you have any thoughts on that? 8 gigabytes is a lot of data.
Yeah, I mean, I don't know how much of it is usable or not. I don't know.
Yeah, right.
I mean, well, I suspect we'll hear about that in trial. You know, because I am still presuming that it's going to go to trial. Obviously, we found out today that they haven't even begun writing this motion to dismiss. I think the motion to dismiss is the same vein as this ridiculous, we need to get our expenses back from, you know, for our expert, right? She's just spending money to whip up the media and the public with these bullshit motions. So it's going to trial. That's probably when we'll hear about that. I'm not really, I mean, I think at this point, it's not like the Commonwealth really requires new smoking gun bombshell evidence, which if I'm being candid, do not believe that they're ever going to get, because most cases don't have that, right? It's just like, again, you piece it together. They need a better presentation, and I feel pretty confident from what we've seen so far that is exactly what they're going to get this time around.
Right. I mean, and hopefully there will be some new data, GPS, perhaps at least GPS of during the triggered events, but there might not be. And that 8 gigabytes could even be, so video uses up a lot of data, and it could be video that was recorded somehow during the testing or something like that. So, which would not be of any use to this, but it would use up a lot of that data. But yeah, so we don't know if any of that will be in any way useful, but they should know by next Wednesday, at least, what the theory is. And we're getting close to the trial. Brennan discussed phone discovery and emails. I'm just guessing that he was referring to Morrissey's communications. Am I wrong on that?
I don't know. There's no indication of that. I will say, getting to the second motion that was filed here, motion for clarification. They're asking for clarification surrounding Karen Read's cell phone. So essentially what they're saying is, hey, you know, the Attorney General's office, they acted as special master, you know, for the taint team procedure because they were privileged materials in Karen Read's phone. And I just want to underscore that again, because I know that Karen Read publicly has scoffed at this idea. Well, that's not possible that there's messages that, you know, anyone saw between me and my lawyer where I admitted doing what I did, because I didn't even talk to my lawyer until that's a lie, obviously, because the taint team procedure was initiated at some point, and that wouldn't have happened if the police hadn't seen something privileged on her phone. And they had the phone, you know, after they, you know, went and talked to her, right? They seized it at the same time. So obviously she
the
did.
phone was taken on the 29th.
Right,
so it
right,
didn't happen after that.
Yeah, so she did have communications with her attorney on that phone, or there would be no taint team. But regardless, so they got a report back from the taint team, but they didn't get the raw data. So Brennan's going, well, can you clarify what's protected here as far as that goes? Because we'd like the raw data to be able to forensically look at her phone, particularly Google searches and things of that nature, right? So he's pretty much saying, like, we're prepared to go through with a special master if that's what we have to do, but we'd really like that raw data to look closer at the phone. So we'll see what happens there, but that could be part of what he's talking about as far as cell phone data, is they are looking to get more of Karen Read's, and specifically her Google searches are mentioned.
And just for people that are interested, so that phone was taken about 4:00 that day by Troopers Proctor and Buchanan. She didn't give it the password, and so they use a machine, I forget what it's called, Gray something or whatever, that cycles through all the possible combinations, but it takes a long time. And so the troopers weren't able to get into Karen's phone until August. So it took months for them to get into it. So, and then at some point early on, as they started looking through it, they found attorney-client communications, and so they stopped searching and put it into the taint team process. So that's what Kate was talking about. So the neurologist report is something that they're waiting on. Is this possibly going to be a new addition where they, for instance, explain that John likely lost consciousness early, you know, from the impact? What do you think? I'm just guessing on that. Kate, you still here? Oh, we lost her mic. Let's see if I can. No, she is muted. All right. So there was a report on. So Brennan explained that they're waiting.
Sorry.
Oh, that's okay. Neurologist.
Yeah, I wouldn't speculate on the contents of the report because I just don't know. But it sounds like they did retain a new neurologist, right? Yes. I thought it was interesting too because they said Dr. Wolf, and I know. Right? Yeah. But I'm going to go ahead and assume that it's a different Dr. Wolf that they've retained.
Right.
But it sounds like, yeah, I mean, obviously, you can see Hank's trial strategy here, which is that I'm just honing in on the facts of this case. I am done with all the speculation. And I think that, really when you're looking at him trying to do things like exclude Marie Russell and exclude Richard Green, which I don't think is going to happen. I would be surprised given her reaction that they even hold a hearing. As far as Richard Green goes, not that I think that it matters really, because just in that hearing, arguing for the hearing, I think Brennan pretty eloquently identified a lot of concerns about Richard Green that are probably going to eviscerate him on cross. So it is what it is. But I think what he's trying to do is really take an aggressive swing at getting rid of all the speculation period. He just wants to focus on the facts, right? So he seems to be just trying to buttress the case. So I'm sure that whatever the neurologist comes back with, if they're using him grabbing this report, is going to, further just support the idea that yes, John O'Keefe was hit by a car, because we know that he was. So at this point, it's just really, gathering the evidence and really honing in on that to show, definitively, yes, he was hit by a car. Yes, it was Karen Reed's car. And yes, she left him to die. I still think, I don't know how they're going to prove when she knew that he, had been hit and was dead or dying. But I think that it's interesting that they're looking into her Google searches now. So.
Yeah. So what do you think about, is Alessi now the main lawyer here? Because I thought he was just going to be kind of focused on the dog bite stuff because he had a prior case involved in that, I think. But he seems to be the main lawyer now.
Yeah, I just can't figure out why.
Yeah.
I wouldn't say main lawyer. He's not really. Yeah, I don't know if main lawyer, but he's definitely taking over most of this pretrial stuff. I don't really see why. I feel like it would appear anyway that he annoys the judge. He annoys me, if I'm being completely honest. So I might be projecting a little bit of that onto Judge Cannone. I think his arguments. I mean, at one point he almost argued himself into a Daubert hearing, which I thought was like, what is this guy doing? Right? The judge even said, like, so you're saying that we do need a hearing, right? Like, it was just it's bizarre the way that he argues his points, and I try to give the guy some leeway. You're only as good as the argument that you're trying to make, I guess, at the end of the day. But I would go with Jackson over him. I don't really understand what's going on.
I know people will get upset with me with this, but I actually think Alessi's pretty good. Listen, I get the boring thing, but this is how trials are, right? And you're listening to them make very legalistic points. I thought, despite that question by the judge, I think overall he won the day here, and the judge made that. When I say he won the day, in the sense that if the goal of Brennan really was to get a Daubert hearing, I don't think he's going to get it. I think the judge made that pretty clear at the end, that this is a matter of opinion, and no one's questioning Richard Green's, that he actually had a methodology. I don't think they really poked much of a hole into that. And the fact that he has the ability, he has the knowledge to do this, I don't think anybody really questioned that. I don't think they really put much of a hole in that either. So I don't think they're going to get a Daubert hearing on this. So I think Alessi's pretty effective. He's not Tom Cruise up there that's going to blow us away and entertain us. But, neither is, except when he gets fired up, neither is Brennan. Brennan is, his routine is kind of similar. He's effective. He's thorough. He's not up there to entertain us. He's up there to get the job done. And I think they both do a good job at it.
I think his arguments are more coherent and well thought. And again, like you're only as good as the argument that you're trying to make at the end, no matter how you try to make it, right? Like as far as that goes. And I think that Alessi, for the most part, has been tasked with losing arguments. And like today, I think ahead of it, I felt the same way about Marie Russell, though. It's like that burden to say that they're unqualified witnesses is so high. And we've got Judge Cannone, who, even though they call her corrupt and, hand in hand with the Commonwealth or whatever the conspiracy of the day is, she's really not. And she gives a lot of latitude to the defense. And that's a huge constitutional issue, right? When you start taking away, parts of people's defenses, you really needs to be justified. And I don't think it often is. So I don't necessarily think what we're assuming the outcome of today is going to be, right? We could be wrong. We're not lawyers, but I think that it's a pretty safe assumption. I wouldn't necessarily credit Alessi being effective or not effective in that. He just, he's coming from a much stronger position than Brennan was, but Brennan still, got a lot of information out there. And I suppose getting it out not only to the court but to the public as well certainly isn't harmful to the case that the prosecution has. So
Right. What was the Brennan? I'm sorry, Jackson referred to new evidentiary motions. Any guesses on that they are going to have at some point?
she asked if they were going to, and he said, "Oh yeah, definitely," because it sounds like we're getting. I don't know. Just like, oh yeah, definitely we're going to file a motion to dismiss. And it's always a 50-50 as to whether or not they're really going to do it.
Right.
I mean, just practically, it makes more sense to keep that open than, come back later and say, oh, we got the last round of discovery and we want to file an we want an evidentiary hearing, but, the court wasn't prepared. So I don't really, I don't take a lot of stock in that either. I mean, we'll see. They're going to be done with discovery apparently on Wednesday. It doesn't sound like there's a lot of outstanding items. So I would be surprised if they actually go through with any sort of, meaningful evidentiary hearings, but you never know. I don't know.
Have you communicated with Gretchen since during the hearing or after the hearing? How's she feeling? How's she doing?
I haven't texted her.
Yeah.
She's in the middle of court, so I wasn't gonna be like, but I'm sure I'll talk to her later.
Yeah, wave.
All right.
Camera's on you.
Yeah. I mean, I know. I mean, I think her position is just very simple. It doesn't really need to be speculated on or discussed. It's not. She is a journalist. She does not have a side in this case. She is. Right. It would be against her profession to have a side in this case, and she's got to protect her the tools of her trade here, right? And again, This is not a Turtle Boy situation where they're screaming that they're journalists, but you're actually the defendant in the case. Like, she is a completely uninterested, neutral party. They've turned over what they've had to be compelled to turn over, and she's got to fight it. She no way around it. It's her reputation, as well as from what I know of Gretchen personally, her word means a lot to her. So she certainly doesn't want to say something and not be able to follow through with it. So.
Right, and she's also defending the journalistic privilege, which her lawyer, what he put together actually was well written and articulate. He's not a forceful speaker, but if you're able to hear put the headphones on and hear it, what he said was very interesting and I think compelling. The chilling effect that it would have if you have a journalist give over her notes on something like that, and I think that's what Gretchen Voss is fighting hard for and should be respected for that. So.
Yeah, I think his argument was quite compelling. I don't think that it was histrionic at all. I think they are real valid concerns about, the outcome of something like this and the sort of precedent that it could set. But it sounds like Cannone is still kind of tipped in the, direction of allowing these in. So we'll see. I don't know. We'll see.
Brennan had a really good quote. A little bit of knowledge of forensic data analysis can be dangerous.
Right.
But that's, this is really something that is going to be a huge problem going forward, increasingly, I would say, because we're surrounded by, I've talked about this before, we're surrounded by so much data, right? We're getting to a point where every object in your house, your lamp has a data stream involved in it. That means It has some kind of information, some kind of programming, some kind of running in it. And they're not designed for forensic analysis. They're designed for their own purposes. Just as your phone was not designed to track what you're doing and for some later police report. It's for something else. Like the health app is designed to help you exercise. It's not designed as a location app. It's not designed to help figure out what you're doing. So, but the more and more data we're surrounded by, the more and more there are going to be slipping Jimmy, slipping Richie Green, people that are out there that can earn a living by finding little errant artifacts of data and finding a way to argue, there's reasonable doubt. And I think it's a problem going forward.
I guess. I mean, again, just looking at this, individually, right? Because I don't know what other cases could look like with this, or what the other, potential Richard Greens out there would look like. But Richard Green didn't really hold up on cross-examination with Lally, right? And so I really don't think that he's going to hold up with Brennan either. Probably it'll be a little bit more marked how poorly he's going to do. And he just doesn't have the facts on his side. And I think, Brennan was able to articulate that pretty well. Nobody's disputing the artifact is there. You're just claiming that it means something that it doesn't. And I think that after reading Whiffin's white white paper, which again, like I'm not I don't understand all of this, but one thing, point that he made that made a lot of sense to me is that some of these timestamps or data items, they're not intended for layman or forensic investigation. They're often written, for the programs that they are,
Right.
associated with, right?
Right.
It's like a command telling them how to interpret something or how to do something. So, I mean, I think that's going to be explained pretty well. I think if even the honest Free Karen Reed supporters, not the dishonest or brainwashed ones, but the ones that at least have a modicum of intelligence and integrity in there, they can see that, like, Whiffen and Hyde were by far the stronger experts there by a mile. Like, it really isn't up for much dispute. I understand again what Hank Brennan is doing, and I commend his efforts because I think he really is just trying to cut out all the speculation, cut out all the conspiracy stuff, and stick to the facts of the case. But
Right.
I don't think that Green's going to be a huge hindrance to the prosecution's case at all. I think it could probably swing in the other direction for Karen's case, honestly.
Right. All right. So if you have a couple minutes, let's just see if there's any questions from chat, and then we can call it a day. Go have lunch. So B Chance says, Kevin and Kate, is there any way that Turtle can be not allowed in court? Is he a distraction and speaks poorly of the O'Keefe? So is there any way to get rid of Turtle? It's up to the judge, obviously, but Kate's mic is off again. So,
Sorry.
I was surprised that the judge allowed Turtle in last time, knowing I have to assume that she was giving the evidence on Turtle Boy trying to intimidate and out the jurors in the Chesna trial, which she had been the judge for, and she put her foot down and says, "I don't want any mention of the Chesna trial." So I don't know. I mean, it's clearly here's a guy that's as blatantly as anybody could ever be, that's saying he's going to try to intimidate the jurors. He's going to try to out them if they don't vote the way he does. How does a guy like this get allowed in court?
Because we have a free press. That's pretty much it. I mean, I think she's, and you could tell that she was trying to balance enough to get rid of him for the
The
as far as
witnesses
the
that involved in his
witnesses
case.
that
Yeah.
Right. But I mean, mere speculation as to what he may or may not do with the jurors, unfortunately, even if it's a little bit more than speculation into an educated guess, isn't really going to make it, especially with this judge. I don't know.
Well, it's
I mean,
based on his own statements. It's based on his own statements in other cases and in this case. So I don't think it's really speculation about what he's going to do. He's saying what he's going to do.
Yeah, but I mean, I could say, like, I'm gonna leave here and go fly to Miami, right? I just said that out loud in public. Am I gonna go fly to Miami? Probably not. Like,
Yeah,
I'm
but
just saying, you can.
it's a reasonable thing to conclude that this guy is saying what he's going to do and he's sitting in court. So it's a reasonable thing to err on the side of caution and saying, you know what, we're not in any way inhibiting. And this was argued, I think, in the first trial too. We're not inhibiting his ability to cover this case. It's on camera. You can go watch it and still report on it. You don't need to be there in the courtroom. And his only purpose to be there in the courtroom is to study the jurors. That's it.
Yeah, but I mean, the judge is not going to make those leaps. Like, we know because we deal with them every day, but she's going to be impartial. Listen, I'm not like, like, I'm the last person that would ever defend that schmuck, and I don't think he should be in the courtroom for a myriad of reasons. I'm just saying I would not anticipate that, the reasons that we have are reasons that the judge would even be able to entertain with this, because we do have a free press. So, like, if he is caught misbehaving during the trial, yeah, he can get thrown out, but he's not that stupid. He's able to kind of, he's able to compartmentalize and really have most of his bad behavior be online, speech based. They're not going to take that into account. Again, personally, do I think he should be there? No, I agree. It doesn't inhibit his ability to cover it, at all. The shitty job that he does, he can do, from the basement or from home. But the court's probably not going to limit that, because it's not just about him; it's about other people that come afterwards, and you don't want the government to interfere with the press too much. That kind of goes against the principle of it. So
someone has a question about behavior in court. So let's generalize it this way. We know that in the last hearing, Karen basically muttered something, are you bad or are you mad or something like that, which caused a sidebar. So was there anything unusual interactions that went on today between Brennan or Karen or anybody in there that you heard of or noticed?
Not that I noticed, but it could have happened. Usually on these days where it's like really technical issues, I get really absorbed into like the arguments because I'm trying to understand sort of both sides' perspective on it. So I'm not paying as much attention to like what's going on in the courtroom.
Right. Take a couple more questions. So Chick from the Bricks, who's been very helpful to us, Chick from the Bricks designed or cleaned up that graphic that I had with that correlated the vehicle data with John's phone data. But I'm sloppy with graphics. I don't know how to do that stuff, and she made it look great. So we've shown it many times on the channel. Hopefully, the prosecution has something similar to it. But so she says, do we know if the state is privy to the documentation Kevin reviewed of Mr. Green's credibility? I'm gonna you can answer that.
Yeah, I'm assuming they do. I mean, I don't know. Nobody would really know.
Right.
I don't know.
Yeah.
I know that again. I confirmed like it's the right Richard Green. So, but the
Right,
thing
but-
is, like every time that like an anonymous email or something comes through on Discovery, everybody's like, oh, and there's all these conspiracy theories and stuff. And I think what we're really like not appreciating is that like we're all dickheads watching this from the outside and probably too involved. So like I would assume that most of those anonymous calls, emails, whatever else that come through are either a free Karen Reed or an anti-free Karen Reed person informing the Commonwealth or of what they think they should know, right? Whether it be for or against Karen. So I would assume that if something comes out on social media, yeah, the Commonwealth probably at some point has access to it, and then it gets handed over to the defense. So
I can confirm that some of those anonymous messages are from absolute rogues and scoundrels. I'm just kidding.
Right.
Because I think one of them was for me too. I didn't submit it for that reason, but it ended up there. But anyways, so but I also don't think when in terms of some of that stuff about slipping Richie Green, there are legal things that govern this, and a lot of that stuff is just not admissible or useful.
Right.
There are things potentially where he had a fake 911 call and made a phony statement, and then after he was shown on video that it was not the case, but still I don't was he convicted of that? Was it settled? There are a lot of other things
He took a diversion, so he did have to admit to it.
Yeah.
I don't know whether or not it would be admissible. The reason that I find it to be pertinent is because number one, he made a legal admission to it, right? So he did take a diversion program, which saved him from a conviction long term, right? It's kind of like a quaff situation.
Yeah.
But in order to do that, he also has to admit that he did what he's being accused of doing, and it's pretty clear from the report, what happened, because I was able to pull the full report too and get like the full context of what was going on there. So it really does, I guess, like my point with it is if you're willing to lie to the police, particularly where they give him opportunity to kind of come clean, and he refused and got belligerent. But if you're willing to lie to the police, then you'll probably lie under oath too. Yeah. I've seen screenshots now. People are accusing it of being AI. Like right there is the docket number. I mean, you have all the information that you need. File your own fucking Freedom of Information Act request, or it would be records request through the Sunshine Law in Florida. But file your own request, and then you will see for yourself that that is a legitimate booking photo. I don't know what else to tell people.
It's not easy being green.
Sorry, I figured I'd put that song in everybody's head again. I don't know, man. This guy's put himself out there. He's got some serious, I don't know, things that you don't want to come out about yourself, and they're coming out. But I guess again, not only does he get paid by Karen's team, but if he's successful here, he's going to be in demand by other defense teams around the country that are looking for these little bits and artifacts that can be used to create some level of reasonable doubt.
I don't know, man. I don't really like this guy is not, I don't think he's the existential threat to, the justice system that he wishes that he was. He's a clown. I mean, that's the one overwhelm as I go through his record and what was provided and then going back and getting reports and things. He's just a drunken buffoon, right? He's unsuccessful in his business. I mean, qualified, yeah, but you got to understand, it's pretty broad to be qualified qualified, right? Like there's not a ton of like you don't have to be good at your career path to qualify in court necessarily.
So Rainey down in Florida, yes, we do absolutely have confirmation that Karen Reed caused the sidebar in that last hearing. I have spoken to someone who was sitting maybe 15 feet away. So
yeah,
yes,
as
that's,
have I. So yeah,
yeah,
like
yeah. So absolutely, she has serious impulse control issues that I think are a challenge for her attorneys to have to control. I think it's something they have to. When she's not in the room, they're probably strategizing like, how do we control Karen? You know. I mean, it's what a client to have that, but opportunity of a lifetime for these guys, prominent trial, getting your face on TV, I mean, how much business does Alessi get out of this, from being this prominent in this case? And like I said, I think he's done a good job. I think he is an very capable lawyer. And you see the difference too between Alessi and the guy that Gretchen Voss has up as a lawyer. Now, I'm not saying he's not equally intelligent or capable in his own way. I don't know anything about him, but he's not comfortable being up there making an argument. So it's it takes a lot of experience and some skill and right personality to be able to stand up and argue forcefully in front of a judge. It's not easy to do that. We would like to do it, but so unless I don't see any more, let's see. Barbie she was referring to Bill Reed making a comment to Hank. I didn't see that, and it's too difficult to rewind this. So I'm sorry, Barbie, I won't be able to answer that. So it's not easy to rewind it. So all right, so I got to go have lunch. These morning hearings are long, and but it looks like we got a lot of hearings to come. As we know, it accelerates as you're getting close to trial on April 1st. Right. So we may or may not. We're going to get a ruling by Monday as to whether or not there'll be a Daubert hearing next Thursday on Rich Green. Unless the judge has a change of heart or sees some stronger argument, it sounds like she's already decided that this is just a matter of opinion. And so I don't think there will be a Daubert hearing. But that would have been interesting because, as Alessi said, very rare, but not unheard of, when you bring in competing experts. So that would have been fascinating to have Hyde or Whiffen in the courtroom at the same time as Rich Green. I really was looking forward to that. Now, it's not like they're going to be sitting across from each other at a table, but still, there would have been, however, I'm not even sure what the format for such a thing would be. Obviously, Hyde would be sitting with the prosecutor. When it's her, do they flip back and forth, having her go up to speak on the stand? I don't know. It would have been potentially really must-see TV. So hopefully they do it, but I don't think they're going to do it. I think that's just something that is unlikely to happen at this point.
Yeah, I think so.
As far as the ARCA guys, the last question from Laura, will they be allowed to testify? If so, the state is looking for, I think so. I think so. I'd be curious to see if they've changed any of their testimony, because one of the things that we learned from that motion by Brennan back in December was that he wants to know what other evidence they have received after the trial. And I'm going to guess that the prosecution sent them the text stream data and other stuff like that. And so you're going to ask if these ARCA guys show up on the stand and you say, where you sent that evidence? Can't say no. And then they say, did you look at that evidence? Well, if he says no, that's going to tell the jury a lot, I think. Kate, do you have any last words before we call it a day?
No, I don't think so. Thanks for having me.
Thank you for being here. Much appreciated. Jen Coffendaffer, her audience might still be here. That's Breaking the Case with Jen Coffendaffer. Kate's channel is Masshole Mafia. Did I say that right? I always get these.
Yeah, no, that's correct. That's correct.
The one thing I always get wrong is Grant Ellis Smith's name. I never know if it's Ellis Smith or Smith Ellis, and I don't think I will ever know. I always get that wrong.
I just call him Crazy Grant now.
I didn't mean, I was setting you up.
Yeah.
All right, guys. Kate, thank you very much. And everybody else, thank you. Enjoy the rest of your weekend.